Hello, everybody. If you can hear me, and if I'm even streaming, we will see about that in a second. Let's check 11 alive.
11
Here.
Alive Plus.
Ooh, I don't see it on here. Let's do Judge Kevin Farmer's stream. Here we go.
Under the Georgia Constitution, the district attorney is the constitutional officer who generally has authority to prosecute criminal cases in superior court. In contrast, under the Georgia Constitution, and from our perspective, that's the important part of this, is
Let's go.
this is a constitutional limitation. The Attorney General has limited.
Sorry about the wait. Call ran a little bit late. There are 28 people watching me fumble around right now? Good lord, that's embarrassing. Hey everybody, Matthew. Here now, Kels. 11 Alive doesn't have it. So I discovered, somebody sent this to me last night. I discovered that I discovered because somebody told me, somebody named Emily. I don't know if she wants to be like identified, but yeah, she shared this with me. So Kevin Farmer actually streams all of his hearings live. I mean, unless it's sealed, I assume. So I think we can try this one first, if this is okay with you guys. Yeah, that call was frustrating. I was trying to get this call set up for a while. The person gave me a time to call them, and then they didn't answer. So that was awesome. Hey everybody. So, also I got monetized. I don't know if this stream will work, but in theory there should be something different. I don't know exactly what. I'm not that familiar with YouTube. But in any event, if you can, I'm not telling you to like subscribe or anything, but if you can let me know if you see anything different. Ooh, my mic's not set up right. If you see anything different, that'd be super. Oh, thanks everybody. If you can just let me know if you see anything different. Okay. Yeah, really excited. I'm kind of like every other creator and every other lawyer on YouTube. I'd like to do mostly pro bono stuff, but need some kind of income. There is a dollar sign. That's probably good. Shift this down, maybe. Cat gifted membership. Oh, thanks, Cat. Yeah, Cat was helping me set stuff up actually. Oh wow, yeah, I missed a bunch of stuff. Thank you, Cat. 50 memberships, 55 memberships. I don't know how to thank Factual Lie and Aaron and LaDonna. I thought this said LeBron James, LaDonna Ames. So thank you, everybody. I really appreciate that. Let me see. Does my channel look more or less okay? Yeah, I think so. So I guess we are going to. I'm here because of Cat. So am I, actually. Actually, you know what's really funny is I wasn't following the YSL trial, really at all until I saw Brian Steele get locked up. There was like I couldn't sleep one night, and there was a clip. It was like, see this lawyer get locked up, and I'm like, this guy looks like he sucks. This is gonna be really funny. And then I saw the clip of Brian Steele getting locked up. Yeah, it's a nice day out. So I kind of got clickbaited into that. But from there, the first channel that I watched was Classy's. After that, Classy Beats. So it's really his fault that I got into this. It's because it really got out of hand. Because I was a bankruptcy lawyer like a year ago. I didn't even know like what criminal law was. But yeah. So I guess we're gonna get right into this. I know a little bit about what happened, just based on the how crazy Twitter was going. Wolfenbarger case. Yeah, the Wolfenbarger case. I still have another video that I want to do on the Wolfenbarger case. I've asked around. I got some information on that case. And I want to talk about Cheryl McCollum and the role she played and the role the media played in bringing that case to prosecution. I think I have a pretty good idea about how some of the information and so-called evidence came into existence. They send membership to non-active subs. Oh, okay, wait, to booze and... Oh, that's interesting. Referred by Catnaught Williams? Well, the 133 issue. Yeah, that drove me crazy. Hopefully we have, oh, bots, I got it. Hopefully we have, the state needs to be responding. Yeah, it does. It's two of the same, Don Samuels and Sam, Joel McDermott. I don't think McDermott's talked yet, but I'm pretty sure he's at these hearings. So yeah, without further ado, let's try this stream. And if this doesn't work, we can try the Atlanta, what's it called? Atlanta Community Press or something like that?
Constitutional authority to prosecute criminal cases. Right.
Okay.
And so I guess to cut to the chase then, I mean, because I'm
a big fan of that.
I'm here.
I feel like I'm missing the beginning. Do I need to...
In the morning and...
Is this an okay place? Yeah, Atlanta Community Press Collective. I knew there was a fourth word. Is this an okay place to start? Oh, wait, no, I need to finish yesterday first. I need to finish yesterday's stream first, don't I? That's why I was on 11 Alive's channel. Do we want to finish yesterday's first? I guess we might as well, right? Or should we just skip right to... Okay. The YouTube playbacks, yeah. This channel's... I'll reduce this sound.
And hear Your Honor quite clearly. So kind of fast forwarding just...
Okay, so that is... We'll save that for later.
11.
And then we'll do yesterday's...
Changes what it is.
Part 2. Here we go.
Long.
And civil. Okay, yeah, we'll do yesterday's first. That's fine. So this is going to be mostly the second lawyer's argument, because I think we made it through Dot Samuel's part.
State.
Oh, I need to switch my little thingy. Yeah, okay, we'll do both for sure. I need to take this, this is right in my eyes.
Because I think I'm gonna start, do my best to answer what was alleged and argued, and yet still stick somewhat to an organized presentation of the argument to you. To do that, I'm gonna start with just a key point. Excuse me. First, one of the things that is important is there was an argument about the introduction as if it was separate from count one. I would just like to point out for the record that the introduction to this, which talks about, defines, and articulates facts pertaining to the enterprise.
So I think this is James Marsicano, right? Or Mariscano? And then this is, I know Aaron knows this.
Is actually contained in count one. It is part of count one. So that introduction in the body of the indictment is part of count one. That's just a housekeeping thing. However, there's a couple
I think that was part of his complaint.
Okay.
I think he agrees with you.
Agreed.
Mr. Sam?
We need to remember this for later, because I believe the state argued to the contrary today that I'm drowned out by the loudness. I believe that they argued the state was trying to argue that the introduction was not a part of count one. But we can put a pin in that for later, see if it comes up.
Yeah. Exactly. That's the problem. If it wasn't part of count one, who would care?
Well, and Judge, so I'll get to that. And there's a separate motion, and I think Mr. Fowler will address, there's a motion specifically about the political rhetoric and the
There are
complaint.
many motions regarding the political
Extra
rhetoric.
key.
And Mr. Fowler will be predominantly addressing that. I'll hit on it a little bit. But there's a lot of issues to cover. I'm going to try to hit them all. And Your Honor, the indictment in this case charges the necessary elements of conspiracy to commit RICO. And I want to just, and I know this.
Okay, one more thing. This came up yesterday, but I think the themes of the state's struggles is failing to articulate or understand or argue the distinction between arguing the existence of a conspiracy or a RICO enterprise, as opposed to arguing that an individual defendant was a part of that conspiracy or enterprise. So only been a handful of times, but the defense would argue that, for example, Liberto wasn't alleged to have been part of the conspiracy, or there were no facts sufficient to allege that Liberto is part of the conspiracy. And the state would reply by saying, look, we did sufficiently allege the existence of a conspiracy. So that those two concepts, the existence of a conspiracy versus an individual defendant's participation in that conspiracy, seemed to be an issue.
After, in response, it seems kind of anticlimactic to get up and just talk to you about the elements, but that is what we're here to establish, is whether or not the state actually alleged sufficiently the elements of the offense. And I won't go through all of exactly what is said, because the court has read and studied the indictment. But count one does specifically set out that the individuals charged acted together, individually and as parties to a crime, or as persons concerned with commission of the crime. That is in there. They acted together with unindicted co-conspirators, together and with unindicted co-conspirators. It alleges the date range. It alleges that they did so while associated with an enterprise. They unlawfully conspired and endeavored, and it alleges the enterprise as well as the pattern of racketeering. And then, Judge, and there's a lot in this indictment which the state is very well of, but Part 1 defines the enterprise, and that's where they started a lot of complaints about the enterprise. And in Part 1, it gives the overarching intent of the enterprise. It gives how the racketeering activities are connected.
It's a bad political science paper.
I think I'm on the wrong part. This is Part 1, is it not? Or is this Part 2?
11 alive plus.
Is this the right part? No, I'm in the wrong section. We did watch this yesterday. I need to jump to this part. I'm sorry. I definitely remember hearing I'm glad that I missed that part, because we got to rewatch the bad political science paper. But it is actually this stream here. Yeah, this is where we were. Sorry about that. So this is actually where we left off here. So that's my bad.
General special demurs, but I'm going to focus on the special demur aspect of it. And when addressing a special demur, some of this argument has been couched in terms of general demurs. Has the state alleged enough to pass a general demur? But I want you to focus on the requirements of the special demur here. The court's got to apply the rule that a defendant who timely demurs is entitled to an indictment perfect in form and substance. And this isn't a horseshoes kind of test, like close enough is good enough. If the state wants to put people in jeopardy of losing their liberty, at minimum, the indictment must be perfect. And I'm going to start with a topic that's already been touched upon, but which is the indictment's failure to adequately allege the underlying acts of racketeering. As has been discussed.
Can we talk about that perfection real quick? I'm going to go back to Kimbrough again. To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. Just in that case, they hold that the sparse allegations in that indictment that say nothing at all about the nature of the connection are insufficient to enable the defendants to prepare for trial. So yes, they use the word perfection, and then they qualify it immediately.
Yeah, and I would suggest that the pages and pages of detail in this case, Your Honor,
This sucker's 109 pages long.
Are anything but.
Okay.
So let's start with these underlying acts of racketeering that the state has to prove in order to establish their case. we've talked about how it's a compound offense, right? You got to prove the RICO and you've got to prove the underlying racketeering act, which are themselves crimes. And the Supreme Court has said the indictment must clearly set forth the elements of those underlying compound crimes and the facts that support them. This indictment may do that in a few occasions, but the state has repeatedly alluded to and argued there are a variety of other spots in the indictment that satisfy the Racketeering Act proof that don't contain the elements, that don't contain an adequate application of the facts.
Let me ask you this. Are you going to make a differentiation between predicate acts and overt acts?
Yes, yeah. I'm specifically at this point in my argument talking about those acts of racketeering we call the predicate acts.
Okay, that was something that was confusing me yesterday. I was pretty sure that's what they meant. The judge uses the term predicate acts, but in the Georgia RICO statute, it's acts of racketeering activity. So those are the specific crimes that make the enterprise criminal. And then an overt act is just doing something to further that conspiracy, and that can be legal. The overt act can be legal, but I believe the way they're using it, the predicate act has to be a crime or act of racketeering activity.
Okay.
Right? Those things they have to prove as part of establishing.
That are criminal acts standing on their own.
Yeah, that the conspiracy engaged in.
That fit within 5A or 5B.
Right.
Yeah,
Either
that's
the domestic terrorism or two other acts of racketeering activity.
Oh, hey, Emily.
Act involving that was discussed extensively before. I'm talking about those.
Okay.
Those are compound crimes that must be adequately alleged, and the courts have told us that. And as Mr. Samuel noted, the indictment doesn't identify any act of racketeering other than to say some undefined number included within the overt acts. There's nowhere in this indictment that says this is a racketeering act.
None of them say predicate act. They all say overt act.
And it says any of these the racketeering acts are included somewhere in these overt acts. It never identifies one racketeering act. We are left to guess. We are left unable to intelligently prepare our defense.
The defendants committed overt acts. This is the beginning of part 2 on page 49 of the indictment. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. And then all 225 say they're overt acts. None of them distinguish themselves as acts of racketeering. That's your argument?
We are left to guess, Your Honor.
Okay.
We are unable to intelligently prepare our defense, as the law requires us to.
And I think
be
Ms.
able to.
Dixon was saying some of them set forth in their facts. Let's see. I'm going to go with, on page 84, overt act 152, 153, which is talking about arson. 155 specifically mentions did commit the offense of domestic terrorism. Would that not put a defendant on notice that that's a racketeering act?
Well, then I can talk to you about those.
If it's talking about domestic terrorism.
Do you guys want more explanation on this, or should we just keep going?
And it actually states domestic terrorism or arson, both of which would qualify as racketeering acts, for the purpose of getting to the magic number of 2. Does that not put you guys on notice?
Well, it puts us on notice that they're claiming it's an act of domestic terrorism or arson. It does not put us on notice whether they intend to rely on that or whether there will be proof that that can be one of the acts of racketeering. If you look at this indictment.
Okay, let me just show you this real quick. This is the RICO. Hold on. It's not actually up on my screen yet. I'll share it in a second. Make sure I don't show anything private like I did yesterday. Okay. It's the last thing I need to do. This is the definition section of the RICO statute in Georgia. And this is when they say, yesterday they were talking about 5.3 or 16-14-3, 5A or B. This is the section they're talking about. To be a RICO enterprise, you have to engage in a pattern of racketeering activity, which means, I'll just read it, at least 2 acts of racketeering activity. And racketeering activity is any of these things. So basically, the predicate acts or the acts of racketeering activity are the crimes that make the enterprise into a RICO. And separate from that is 1614-4, which is the prohibited activities. And this is what's being charged in this case. This is what was also charged in the YSL case. It's RICO conspiracy. And this would get to the overt acts. So an overt act is something that you do to help out with the conspiracy that is criminal, but you can help out in a way that is not criminal. So, you can buy, I think the example one of the lawyers gave yesterday was you can buy a gun legally and then give it to somebody who robs a bank, and nothing you did was criminal. But, except for the conspiracy. So an overt act can be a legal act, and that makes you liable for the entire crime. So they're 2 different things. I know it's kind of complicated, but that's my best shot at explaining it. And somebody asked a question. Because we're all charged with RICO, are all defendants charged with arson? No. I know what you're getting at, but you need to charge everybody with those crimes separately. This one? Here we go.
And you listen to the argument of counsel, there is an unlimited possibility of possible racketeering acts. We are left just to go through the indictment and try to figure out which ones they are. Now, as Your Honor points out, where they use the words domestic terrorism, where they use the words arson, that's certainly a key, right?
Now I'll go back to Mr. Liberto, because I can. He attempted to occupy. That's an overt act. There's not a crime described, a separate, independent. There's no second part of a compound crime there, right? Okay. So you can read that. Does that not put you on notice that that's not a racketeering act?
It does to some extent, Your Honor. I agree with you. But for the state to be able to prove to a jury and for a jury to rely on a racketeering act, we've got to know which ones, right? And it's not enough to say that they've adequately alleged some, but they can still prove others, because that's a problem for the special demurrer. We need to know all the ones that the state would be able to rely on so we could adequately prepare our defense. And so, domestic terrorism, arson, it's alleged in separate counts 2 and 3 for January 21st, 2023. So that's probably the state's strongest argument, that one's adequately alleged, that we're on notice that those are acts of racketeering, right? And there are concerns with that domestic terrorism statute that will be addressed in other demurrers. So I want to address those here. And then
we're not addressing the constitutionality of arson, are we?
No, Judge, but there is a demurrer on it, so both of those could be.
I've read it.
But the indictment makes references to domestic terrorism and arson that didn't occur on the numbered counts on January 21st, 2023, right? But they don't adequately allege the underlying facts as they apply to the elements of arson in those paragraphs. They mention the words domestic terrorism, they mention the words arson, but remember, the law requires them to allege the elements and the facts that apply to those elements.
In the predicate acts, but not the overt acts.
Correct.
Okay.
And they haven't done that. Not only do they not mention the elements in regard to the acts on those dates, for instance, the March 5th music festival and the damage to the construction equipment that's alleged to have occurred on that day. They don't mention the elements of arson or domestic terrorism in those counts. They don't mention the code section. They don't explain how the facts alleged in those counts satisfy those elements, Your Honor. So while Your Honor is right, saying there is some indication that those could be acts of racketeering, I don't know that. It doesn't meet the requirements that the law imposes. We're left to guess. There is a mention of assault in the indictment. It's mentioned a couple times. Nowhere in the indictment does it mention the code section. Nowhere does it set out the elements of the crime. Nowhere does it explain how those elements, how the facts meet those elements of the crime. It completely fails the test of setting forth the elements and the facts required for compound crimes. If they mentioned assault, the indictment mentions assault, but how can that be enough to put us on notice of what is that it will be an act of racketeering?
And I think that's the Kimbrough case. It's like, okay, this crime could have occurred in 6 different ways. We don't know which one.
I mean, I'm, Your Honor, preparing for this argument. I'm reading through the indictment, and I'm just saying, what fanciful argument could be made to this paragraph to claim that it alleges an act of racketeering? Because that's essentially what the state has done up here. We're left to guess because the indictment doesn't tell us. But the indictment has to tell us. We have to know what the racketeering acts so we can prepare our defense. We shouldn't have to guess. In fact, we don't have to guess because the indictment must be perfect and tell us.
A.K.A. Hines.
Then there's influencing a witness. It never mentions the statute by name. It never cites the code section. It never gives a complete recitation of the necessary elements of the crime or an adequate description of how the facts satisfy those elements.
I'm still hanging out everywhere.
All it does is it mentions some of the language from the statute in various overt acts in the indictment.
Don't forget which official received.
Right. It just talks about some of the elements. So it fails the test. It doesn't set forth all the essential elements. It doesn't set forth how the facts apply to those elements. And then there are, for instance, it makes no mention of the element that it must be done to persuade another person by means of corruption or an attempt to do so, or to engage in misleading conduct towards another person. Makes no mention of that element. Makes no description of how the facts would satisfy that element. Again, it's a passing reference. We are left to guess. Is this just flourish in the indictment? Or is this an act of racketeering? We don't know. It hasn't been identified. And then, of course, there's the official proceeding problem. The statute defines official proceeding. None of that language is in the indictment, nor is there any description of what this official proceeding that is contemplated to keep the documents from appearing at. How do we prepare for that, Your Honor? We're just left to guess. But we don't have to guess because we're entitled to a perfect indictment. They talk about obstruction. Ask the state to tell you where the elements of obstruction are shown in the indictment. They're not there. And the state rattled off various paragraphs during their argument earlier that they claim allege facts sufficient to show obstruction. Which ones were those? Are they the only ones? Are there others? How do we know if the indictment doesn't tell us? We're going to prepare our defense by the sketchy notes from an argument here by counsel? No, that's not what the law requires.
Some of you don't know this, but indictments are my favorite thing in the entire world. They're my favorite thing to go through. So this is just, I couldn't be happier right now. I don't want to cry.
The law requires it to be in the indictment, and they fail to do so. We can't intelligently prepare our defense. There's some talk of money laundering. Nowhere in this indictment as it stands now are the words money laundering used. the elements aren't set forth, how the facts apply to those elements isn't described. There were counts that originally alleged money laundering, but as you know, those have been dismissed, so they're no longer part of the indictment. It can't inform this inquiry. I mean, I started writing down a list of potential crimes. It's just a pointless exercise, Your Honor, because the state is limited only by the list of predicate crimes and their own creativity to argue to you what's in here. But that's not what the law requires. You got to allege the elements of those underlying crimes. You got to allege how the facts apply to those elements. And they repeatedly fail to do that. Now, it's not enough to say, like it might be for a general demur, they did it once, right? They did it for the named counts in the indictment. They did it for the corresponding overt acts that can correspond to the named counts in that date. But that's not what we're addressing here with the special. We need to know every racketeering act that the state would be allowed to try to prove from this indictment. And we don't know that. And then turning to any act involving murder, kidnapping, gambling, arson, robbery, theft, receipt of stolen property, bribery, extortion, obstruction of justice, dealing in narcotic or dangerous drugs, or dealing in securities, so long as those things are a felony. There's nowhere in the indictment that says this is an act involving ... We know they haven't identified any racketeering act specifically, and they certainly haven't identified them as being one of these 5B, any other act types. Let's talk about obstruction and murder. What are the elements of obstruction? What are the elements of murder? Where does it show us that in the indictment? It doesn't. What are the facts supporting the existence of those acts as the law requires? We don't know. What are the dates? Who did it? What did they do? We're left to guess. So if we're going to guess, Judge, let's guess. What about the acts described in Part 1 of the indictment? They're explicitly incorporated into Part 2, describing the overt acts, and they say all the overt acts could be acts of racketeering. Could some of those things from Part 1 be the racketeering? Did the state prove at trial to a jury to support a conviction? It talks about Rayshard Brooks. Well, he was shot while pointing a taser at an officer. Is that not an act involving obstruction? Is that a racketeering act that the state can rely on to prove these defendants guilty of RICO conspiracy? It talks about the murder of George Floyd. Are we to assume that the murder of George Floyd is an act involving murder that qualifies as an act of racketeering, supporting a conviction? That we defendants must now be prepared to meet and address at trial? Judge, these examples seem absurd, but they flow directly from the state's theory and argument as to what they have to show in this indictment. Just wrong. The law requires the state to tell us what we're defending against so we can prepare our defense. The state's theory would make it wholly impossible for us to do that. What about acts involving arson? Again, as we talked about, there are some specific numbered counts that address arson on a specific day. The state's arguments, pretty strong, setting aside the other arguments, that they've done what they need to do to identify those acts as acts of racketeering. But as we know, it goes far beyond that. How many of the alleged overt acts involved arson? The indictment doesn't tell us. Which other ones involved arson? How do the facts of those yet unidentified overt acts map onto the elements of arson? We have to guess. It seems that the state's argument is the only limit to the act involving style overt act, predicate act, is they have to allege some fact somewhere that might arguably support it without notifying us, without setting out what the elements are, and without explaining what the elements apply to that. That's simply contravened, as Your Honor has pointed out, by Kimbrough and the other cases addressing compound crimes. They focused on other acts involving arson and obstruction today. What are they going to say at the next hearing, for the next motion? What would they allow to be think up next time? How will we know? When will we know? When will the jury know? Will we find out before the jury finds out? The parade of horribles, Your Honor, is endless. That's why we have the law that requires them to identify everything. And, even if we were to concede the aspect that some of these overt acts adequately set out the facts of some crimes, which we don't, and the indictment doesn't, the indictment still fails the test of a special demurrer in many ways. It fails to identify the facts that support any given racketeering act. It fails to set out the essential evidence, and sometimes it suffers from both problems, as I previously discussed with some of the other potential hypothetical racketeering acts, yet unidentified in the indictment. The Supreme Court's clear. The state must provide us this information so that we can prepare a defense. And this indictment makes such preparation impossible. And then from there, we can zoom out beyond. My argument to this point has been focused exclusively on those acts of racketeering, those predicate acts. But we can zoom out from there because the state has to prove more. They have to prove all the elements of the RICO conspiracy itself beyond the underlying acts. And I won't bore you with going through all the elements of that.
Oh, no, please, by all means, bore me.
So the defendants got to endeavor or conspire to violate subsection B as alleged in the indictment. So they have to be, that requires them to be associated with an enterprise. And so they've got, that enterprise must exist. And that enterprise is at a minimum an association or group of individuals associated in fact.
No, you said B. There's many B's here. We're talking code section?
Yeah,
Or we
16, 14, 4. And I'm referring to the sort of start of count one of the code sections they refer to in the indictment.
Mm-hmm. Okay.
And they must endeavor or conspire for someone in that enterprise to be engaged in a pattern of racketeering activity. That's all the things we've just been talking about. It's either the two racketeering acts or the one act of the domestic terrorism. And the defendant must commit an overt act. Right? That's kind of gets us to our universe of elements that they must prove and frames what the indictment's got to put us on notice of. And Your Honor's honed in right away on one of the big ones. What's the nexus between the overt acts and the conspiracy and enterprise? It's hard to answer that question because we don't know what the enterprise is, Judge.
Isn't the enterprise set out in...
Is it the Defend the Atlanta Forest? Is it Network for Strong Communities? Is it one or the other? Is it both? We can't tell.
According to the indictment, defend the Atlanta Forest is a self-adopted coalition and enterprise of militant anarchists, eco-activists, and community organizers. But that is the enterprise. That is even, because part one is the enterprise. A, introduction. B, defend the Atlanta Forest. Then we get into the background of the Atlanta Forest. And C, D.
Yeah, and this kind of gets back to yesterday when they were discussing the fact that there are events alleged as overt acts that predate even the planning of Cop City, of the training center. So saying that the enterprise is defend the Atlanta Forest just doesn't make sense. Cop's name is Carmi after the bear.
Beginning of the defend the informed enterprise. That's where we get Mr. Floyd and Mr. Brooks. So the indictment says defend the Atlanta Force, the enterprise.
Right, but what is it? That enterprise must engage in a pattern of racketeering activity, right? And so it has to have, that enterprise has to be the vehicle through which the conspiracy is committed that has an object or a goal. And that is what those objects and goals are so broad and ill-defined. It's unintelligible. It's so broad, as Your Honor pointed out,
Your Honor,
it talks about the black-clad defendant Atlanta Forest participant states that the fate of the Kurdish revolutionaries in Kobani and Seri Nave and all these places, it was partially determined by the bloodbath in Damascus and Aleppo. That's one of the objectives.
11 Alive Plus.
Enterprise inside the conspiracy. We have to be prepared to defend against that. Does that mark one of the outer limits of it? Is there going to be proof of Aleppo? Is there going to be proof of the unidentified person at trial? We don't know who it is by the indictment. We don't know the relevance. But not only does it say too much, it gives such a broad and vague universe of things that are included in this enterprise and conspiracy that it then fails to give enough detail about the ground it does cover. It would require at least another 100 pages to give us enough information to put us on notice of what these things are that they are even talking about in this section. Aleppo, Damascus, masked individuals that are unnamed. And the jury's going to have the same problem if a case like this is allowed to go to the jury as indicted. How's the jury going to know what the enterprise is, what the conspiracy is, what the objects are? Now, we've talked about ways that you can limit that beyond a demur, redacting the indictment, striking surplusage. But we're not, as Mr. Sandy pointed out, we're not talking about removing a word here or there. We're talking about the need for wholesale change to this indictment that fundamentally changes what it is. It's hard for me to even identify what demurs would remain if we start striking whole swaths of the indictment. Of course, the ones where the state fails to allege the elements of the compound crimes and the facts that apply to it will still be there. But what about the rest? I don't even know. The jury's got to know what's been alleged, right? We need to be able to determine if there's a fatal variance between what's alleged and what's proven. That's why they've got to tell us what these racketeering acts are. Because we have to know, have they alleged it or have they not? We need that to prepare our defense. I go through in my motion that detail, and it seems like Your Honor had a chance to review it, of all the questions, count one, the part one, just defining the enterprise phrases, failing to define certain things, failing to identify other things, failing to explain how the enterprise is a subject, define the enterprise.
Well, we're talking about Mr. Schwartz's motion here, right?
Which I think was my motion, Your Honor. Sorry, Mr. Schwartz's motion.
He's stealing your thunder? He's co-opting your. I've got on number 3. I've got Mr. Schwartz's signature on the last page.
He's arguing, we filed a motion. I think 3 of the 4 of us did.
Pardon?
3 of the 4 of us filed the same demur.
Okay.
But
I just got the one with your signature. I look under your client, I'm going to find the same motion with your signature.
Yeah, I don't think I'm talking out of turn if I say it was just a copy and paste of my motion.
Was it good?
We'll see when I rule, won't we?
See, you're allowed to laugh when the lawyers aren't the joke. The lawyers can joke and it's okay. The judge can joke if it's okay. But if you are a joke, it's not okay.
And so I hate to go through, this 53-page demur, right? I hate to go through every question that this indictment raises. I think Your Honor has
46. Okay.
Okay. It has reviewed it and sees all the questions this indictment raises. It doesn't describe the alleged criminal purpose of defendant Atlanta Forest. It doesn't describe how individuals joined the conspiracy. It fails to describe the acts of racketeering activity, and the list goes on and on about all these vague concepts that are introduced but not tied in, not given a nexus to what we're dealing with here. All right, and then turning to part 2, which the overt acts. The indictment sort of breaks these down into various categories. Payments, the indictment. The demur breaks these down into payments, online postings, the January 21st protest, the March 23rd event, the flyers in Chupa Saucedo's neighborhood, the forest occupation, property destruction, and uncategorized.
You're on part 2?
Yeah, the indictment.
Oh, the indictment. Okay.
Yeah.
I thought part 2 of your demur.
Well, which is titled, part 2.
Online postings.
This is the trial list here.
Yeah. Roman numeral 2. Number 2 within Roman numeral 2. So you have to back up to get to Roman numeral 2. Payments would be 1. Online postings is 2, and above that is Roman numeral 2, describing Roman numeral 2 of the indictment, which are the overt acts. Am I making sense yet, Judge?
No.
Okay. The indictment alleges overt acts as we've talked about. And part 2 of the RICO count, pages 49 through 100, alleges 225 overt acts.
Mm-hmm.
Right? And so those acts raise all kinds of special demurrer problems. So I just want to turn
225 of them, I imagine.
greater than 225 problems for the 225 alleged acts. And those are the ones that I just described, payments, online postings, and so on. They kind of break out into categories, even though they're not explicitly done that way in the indictment.
I think both sides have categorized them.
Yeah. And so a variety of questions keep rearing their head with these overt acts. What's the nexus between these acts, be them racketeering or overt, and the alleged enterprise and conspiracy? How are the alleged acts connected to the enterprise? How did the alleged acts further the purposes of the conspiracy? How did the defendants not named in the acts conspire or endeavor to further them? For example, when you look at the January 21st protest, the so quote-unquote night of rage.
Now, at some point, there's a difference between a proper indictment and adequate proof at trial. We can agree on that, right?
Absolutely.
They don't have to prove their case in the indictment.
Absolutely.
Okay? They allege the nexus, but then they're going to have to prove that nexus. Right? But if you're just saying the allegation needs a little better, a little more work.
Yeah, I'm not sure they allege the nexus, Your Honor, in
I'm
these.
saying they have to.
They have to, that's right. And that requires answering some of these questions that we raise. Maybe not every question, Your Honor, right? It's kind of one of those things.
There's a lot of questions.
There's a lot of questions, but you may not have to get all of them, but you got to get some of them to put us on notice. I raise every question that could be asked. Not every question has to be answered, but somewhere, some fundamental aspect, some of those questions have to be answered to put us on notice. And I agree. They could answer some, but not all of them, and they'd meet their obligation. They haven't answered any of them, Judge. This January 21st, night of rage. How did an individual on a different day that wasn't there conspire, endeavor to have that happen? Well, we don't know. We just have to guess. And so, turning to the overt acts alleged, the category of payments, there's all kinds of these alleged payments that mostly allege Savannah Patterson, Marlon Cutts, and Adele McLean reimbursed others for various items with the funds from the Network for Strong Communities.
Look at this highlight.
And given that the money laundering charges have gone by the wayside,
Is this a racketeering act? We don't know, Judge. We don't have to guess because the indictment has to tell us, and this indictment doesn't. And it talks about all kinds of items that were paid for. Forest monitoring equipment, you saw it in the demur. Forest monitoring tools, food, gloves, tarps, power packs, deep May tuition, glue, bins, generator, restroom support, tools. I mean, the list goes on and on and on and on and on. How did any of those?
I want to show an example real quick. I referenced this during Cat Stream today. Let me show you. This is from the YFN RICO case. So this is a Fulton County indictment. This is a Fonnie Willis indictment, and I want to give credit. You see here saying these are overt acts and acts of racketeering activity. So they're specifying acts of racketeering activity and overt acts. I believe some of these are going to be just overt acts. Yeah, so this one here, these are just overt acts. They're not acts of racketeering activity. This is an overt act and a predicate act of racketeering activity. There's still a mistake in the indictment, but that part is reasonable.
Things further the conspiracy. What's the nexus between a tool and the conspiracy? Between a power bank and the conspiracy? I don't know. It fails to describe how each item was used to further the conspiracy. It fails to describe how the transfer of funds was made. It fails to describe how or if the act was connected to the enterprise, how they furthered the RICO conspiracy. Like I said, maybe you don't have to answer every question, but you gotta answer some. We've got to know what we're facing. And of course, as previously been identified, and who are the unidentified co-conspirators whose identities are unknown to the grand jury. Not only do we not know if it was the three named defendants, it could have been any number of people that we don't know that did these. How do we defend against that, Judge? We can't. Then we turn to the online postings. They generally allege that Cops, Patterson, and McLean, and then again other unindicted co-conspirators, posted to scenes.noblogs.org to threaten others. We don't know how they posted the post. We don't know the content of the post. We don't know how it furthered the conspiracy. We don't know who's the target of the threats. We don't know how these posts demonstrate that they intended to cause and induce the alleged target of the threat to withhold record documents and testimony in official proceedings. Is this a witness influencing act, predicate act, active racketeering? I mean, it mentions some of the language from the statute, but it doesn't meet the requirements of setting out all the elements and how the facts apply to them. What are the documents that they're trying to get them to withhold? What's the official proceeding? How's it connected to the enterprise? How did it further the RICO conspiracy? I mean, these questions repeat over and over and over again in this indictment. This indictment raises many more questions than information it provides to us on how to prepare our defense. And then we turn to the quote-unquote night of rage on January 21st, 2023. What's the night of rage, Judge? Do you know what it is after reading the indictment? I don't. How did these actors join the night of rage? It doesn't what was the arson that was committed? How was it committed? Again, what were the elements? How did the facts apply to the elements of arson? Is this an act of racketeering? Or is it not? Is it just an overt act?
Does it not appear from the indictment that someone took a hammer to try and break into a building and set it on fire? Now, where the Night of Rage moniker came from, that's a whole other issue.
I would submit that it doesn't, Your Honor. Let's go to Acts 152.
I'm getting there. Yes, 152.
And are you referring to 156? Did possess a hammer while attempting to break into 191 Peachtree Street?
Well, 155, possess an accelerant while attempting to break into 191. Did possess a hammer while trying to break into? Now, I don't know how spray paint has anything to do with arson. That's 157.
How's that connected to the Night of Rage? We don't know. What the Night of Rage is, we don't know. We don't know what the property damage might be. Maybe it's breaking a window. Say they had a hammer. And then,
As I said, there's perfect, and then there's perfect.
and how is this domestic terrorism, Judge? How is this described?
That's a different motion.
Well, I mean, it says it right there
Oh, I know.
in 155. Commit the offense of domestic terrorism. How do these facts establish the elements of domestic terrorism? We don't. They don't, Your Honor. The allegations of these facts is wholly insufficient. Had a gas can, had a hammer, some spray paint, attempted to break in.
I'm just going to show that real quick. This is 155. This is what he's referencing. Francis Carroll did possess a lighter and accelerant while attempting to break into 191 Peachtree Street in Atlanta and did commit the offense of domestic terrorism. So that is that is quite vague.
And that's supposed to satisfy the elements of domestic terrorism? I don't think so. The indictment doesn't meet the requirements of adequately alleging these predicate underlying crimes that's required when they allege a compound crime like RICO.
It says domestic terrorism would lean more toward arson, but okay.
Is that a racketeering act that we have to be prepared to meet, Judge? Might be, but that's not enough for me to say it might be, for you to say it might be, for them to argue, oh, it is. The indictment has to tell us. They don't get to tell us. The indictment has to tell us. And these questions repeat over and over and over again. Like I said, it doesn't have to have every fact we want to know, but it's got to give us enough to know how's this domestic terrorism, right? And let's turn to the March 5th event. This is the music festival and the damage to the construction equipment. Many questions arise here. Where did the criminal trespass occur? How were the elements of criminal trespass committed? How did the criminal trespass further the occupation of the DeKalb Forest? How is it connected to the enterprise? Remember, we don't have to answer everyone. We've got to answer some of these. I mean, we don't even know where the trespass was supposed to have occurred. Was it where the music festival was? Was it where the construction equipment was? Was it both? These are areas where the ownership and ability to exclude people from the land is not clear based on an indictment. And we know that there are areas that the city had under control and areas that the city didn't have under the control. Which one was it? How do we know? We can't. How is the mob organized? How did the mob cause property damage? Where did the mob attempt to cause property damage? These are things that are not in the indictment that we don't know. And I mean, they're set out in detail in the Demurrer Judge, all the different questions that could be asked. But it also talks about domestic terrorism, talks about arson. We need to know the elements. We need to know how the facts apply to those, and the indictment doesn't do that for us. How it was connected to the enterprise and how it furthered it. Then we've got the flyers in Trooper Saseto's neighborhood. How were those connected to the enterprise? How did they further the conspiracy? There's the forest occupation. Where did it occur? How is it connected to the enterprise? How is it connected to the conspiracy?
Are you looking for GPS coordinates, sir?
Well, I mean, when it comes to the trespass, when it comes to the forest occupation, we need some definition, some description of where they were allowed to be and where they weren't. And this indictment doesn't point us to that. And the questions are the same in the group of the property destruction group of acts. For instance, how does the indictment tell us that by vandalizing a Brassfield and Gorey office building in Colleton County, they demonstrated that they had the intent to cause and induce Brassfield Gorey officials to withhold record documents and testimony in official proceeding? What's the nexus between those two things? What's the connection? We're left to guess. What's the official proceeding? And how did those acts connect to an effort to get them to withhold documents? For each group of acts, the same questions can be asked over and over again because they remain unanswered. In the end, Judge, we're left with an indictment that doesn't tell us what we need to meet. We're left to guess. And that's a result prohibited by Georgia law. And that calls for granting of a special demurrer.
Okay. Before you jump up, I'm going to take 7 to 10 minutes, and then we'll be back. And who's going for the state?
On this one, the Dixon is going to continue on this one.
Okay. Take 10, y'all.
Or on Dorsey, this Georgia.
All right. Can I play this like slightly faster than normal? Let's see if this works. I'm just itching to get to tomorrow. The filter team issue, yeah.
Supreme Court case that specifically held that. And I know I get to reading too fast at times. I'll try to make sure and let me just read a little bit more and not try to go so fast. Okay. Dorsey challenges, excuse me. This is the Dorsey v. State case.
Right. No, I remember, yeah.
Okay, all right.
This that Mr. Sanders vehemently disagrees with, but it's still good law.
It's still good law. And just so that we understand, just why Mr. Samuel so vehemently, and I understand.
Samuel said that he understands that it's good law. This isn't even a contested point.
Good for his client.
Well, and I mean, I
Or for Sheriff Dorsey.
Definitely. But Judge, just to give it some perspective on why my answer to that is no.
Samuel's admitted that it's no, and the judge agrees that it's no. What are you doing?
Dorsey challenged Category 5, which I talked to you before, predicate offenses.
Right.
Each concerning an act involving murder. The basis for his challenge is that a preparatory act, which standing alone may not be criminal, cannot constitute a RICO predicate. And then it goes on to say it belies that claim. And then it goes on to explain that under subsection B, 5B, so it's, we know which one I'm talking about, it does not have to be a criminal offense.
Gotcha.
Okay, all right, so that's the answer to that. As far as the argument raised by Mr. Garland, I'm going to...
But if it is a criminal act,
Yes.
then you have to delineate
Yes.
and put forth all of the elements of that?
If it is a criminal act, you have to put forth all of the elements, all of the essential allegations and elements of the offense within the indictment. Yes, sir. Not within that one
Even
count.
if it's not if it's one of the 225 overt acts?
It does not have to. Okay. So for a predicate act, yes, somewhere in that indictment.
If the predicate act
Yes.
is also a criminal act,
Yes.
then if it is enumerated within the RICO count, it needs the elements of the offense.
The state's contention is that as long as the indictment, read in the whole, sets out all of the elements of that underlying offense.
That's exactly what Kimbrough said you can't do.
That Kimbrough was not a compound felony case, I don't believe, Judge. I don't believe, because that same...
It was a RICO case that dealt
It was a
with
B.
drugs.
But it was not a conspiracy to commit RICO.
It's still going to be a compound offense.
And technically, a conspiracy to commit RICO is like a doubly compounded case. And I mean, to be quite frank, I haven't read the Kimbrough case since September of last year.
Okay, there's a lot to unpack there. First of all, you should have read the case. But even, why are you telling them that you haven't read the case? Don't self-snitch. Also, read it.
In great detail, but I have read the Sanders case, which is in 2022, and it specifically states that...
I've read the case that's good for me. I haven't read the case that's bad for me. Therefore, you should rule on my side, because I read the good case.
In compound cases, or twice compounded cases, like conspiracy to commit RICO...
Well, I think Kimbrough's even worse for you because it's not compound. Compound, you got to do it, but Kimbrough says you got to do it in a non-compound case because in Kimbrough, because I read the Court of Appeals one first, read what they did wrong, and then go see what the Court of Appeals tells them they did wrong. And in the case at the Court of Appeals level, they said, hey, see as follows below. Not unlike...
And the judge has clearly read Kimbrough. And this is after lunch. You could have read it during lunch.
Your page, part 2 on page 49. The defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described. See below.
Yes, sir.
Okay. Now this is all in one count. The problem with Kimbrough was that was count 1, and then they enumerated the other counts. You just enumerate them as separate overt acts.
Yes.
But they still wanted, you couldn't read it, specifically they said it's not a read as whole kind of thing.
I don't know, Judge, quite frankly. I mean, I would have to really compare, and we can
I would have to read the case.
do that. But what I know is...
We have held that an indictment not only must state the essential elements of the offense charged,
Yes.
but it also must allege the underlying facts with enough detail to
Did
sufficiently
she say since September? That was a year ago.
apprise the defendant of what he must be prepared to meet.
Yes.
Okay, and that's the English case also as well.
Yes.
And they also kind of get a little upset that the indictment says nothing more, however, about the nature of the alleged connection between the enterprise and the pattern of racketeering. These folks are asking for greater detail about the connection by their special demurs. And this is Kimbrough on page 880. Go ahead.
So Judge, I don't know where we're.
Where we are was not every predicate act has to be a criminal act.
Yes.
Endorse it.
Yes. And.
But
and
if it is a criminal act,
if it is alleged under A, yes, sir. Or domestic terrorism, yes.
if it's a criminal act,
Yes.
because it can also be a criminal act, it can be a criminal act under
Yes.
B.
Yes.
If it's a criminal act, you have to set forth the evidence.
Within the indictment, yes, sir. Or facts. What does this? Let me quote it.
Kano says car crash in ultra slow motion. Before the hearing, one of the defense lawyers told me that he expected a slow motion train wreck. I messaged him today and said it didn't seem like it was all that slow motion. And he was like, yeah, that took a turn.
The state's position is
And
that
you're at Sanders.
yes, sir.
right.
On page 200, and I.
In order to satisfy due process when an indictment charges a compound felony, such as felony murder.
Okay,
but
I
here's
just pulled up
conspiracy to
Kimbrough.
commit
We need to have
RICO.
I need to show you this. This is egregious. Hold on, let me download it here. I just want you to see how short Kimbrough is. I mean, I hadn't read it either, to be fair. Although I was just able to acquire it since we started talking about this. Let me pull it up here. So this is the opinion right here. I'll make it a little bigger for you. So this is the case we're discussing. Okay, so this is Kimbrough. This is how long. Oh, that's really funny. This is done. I believe that's Don Samuel's firm. So I think he mentioned this yesterday. It's like 4 pages. And mostly footnotes. It's 3, 4. It's like 4 and change. If you ignore the footnotes, I have the inline footnotes, but if you kept them as footnotes, it'll probably be like 2 or 3 pages. I'll show you in the this one? Nope. Let me see. This one? Nope. I don't know. But yeah, it's just a couple of pages long.
The count
It's very short.
charging the compound offense, which here's count 1,
Yes, sir.
and the listing of overt acts. I insert that.
Okay, I found it. I'll show you just the regular way. Without the Westlaw head notes. It's just this. That's the whole case right here. It's like two pages and change, maybe.
But the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely. That didn't happen here. It did as far as the arson and the domestic terrorism.
Yes, sir.
But the rest of the stuff, not so much.
Right.
Or the indictment must elsewhere allege facts showing how the compound offense was committed. Okay?
Yes.
So Mr. Garland was up here saying, show me my essential elements. When you say where there's one count where it's just, this is domestic terrorism, I'm going to hope that you will admit that that's a predicate act.
Yes.
Okay, so he wants to know where are the essential elements of that. And let's count.
Which paragraph, Judge?
152.
Oh, I know that one, Judge.
To join the Night of Rage in Atlanta and
Did she say I know that number?
152.
Oh, I know that one, Judge.
To
I
join the
know
Night
that
of Rage in
one.
Atlanta
Okay.
and cause arson and property damage and thereby committed the offense of domestic terrorism.
Yes. So my answer to the question of where are my essential elements is count 2 of the indictment, which is allowed under Sanders. With that, you said or. So it's either in count 1 or alleges another count in the indictment, count 2, or sufficient facts to show how the compound offense was created. We're under 2 for that.
So you're relying on count 2 for that.
Yes. To establish the, yes, sir, for the domestic terrorism.
god. I fell for this on Cat Stream, and then I fell for it myself. What was that? Okay, we're... Sorry about that, everybody.
So how is that not leaving it up to the defense to figure out which predicate acts they need to defend against? Because let's say there's only 5 of them, they can knock out 3. They win, right? Well, you gotta have 2 predicate acts. If you only got to get 3 to win, okay, Mrs. Samuels?
I did mention that I'm not good at math. Did y'all?
I'm mathematically correct, am I not, Mr. Samuels?
We win if we knock out 4.
You win if you knock out 3.
There's still 2 left in your...
No. If there's only 4 and you knock out 3, there's only 1 left.
Lawyers, you're making us look bad right now. Come on. I need you to tighten up.
Okay.
I'm lost. I thought he said 5.
So,
Yes, sir.
if they don't know how many predicate acts they have to defend against, how is that not leaving them to guess? Because they're going to marshal their energies. Because if somebody bought food, and that's an overt act, they might not give a fat baby's behind about fighting that one. Bought food, and that's an overt act. They might not give a fat baby's behind about fighting that one. They may say, yeah, my guy bought food.
Yeah.
Okay, so how are they not left to guess which ones are and which ones aren't? Because some of them are crimes, and you're saying, well, it's pretty obvious that this is a crime. But on the other hand, you're now telling the court,
Fat baby's behind.
well, predicate acts don't even have to be crimes.
That's true.
Under Dorsey. Agreed.
Yes, sir.
How are they supposed to know which is which?
Based on the contents of the indictment and the allegations and the statute.
Sorry, I gotta take a screenshot real quick. Sorry, I just gotta add that to my collection. I'm sorry for the interruption.
And how it's defined. And in fact,
And I think if
Sorry about
you
that.
would have said, hey, this is a predicate act under 5B, this is a predicate under 5A, Roman numeral, whatever, if you had identified that, instead of leaving it up to them to guess, they would know how many out of 225 are the predicate acts that they've got to marshal their resources for.
I do not disagree that if we had delineated, that it would make it easier and better for the defense.
How about
and
we call it perfect?
Well, perfect in the sense that it's not actually required as the state's position, because they offer no authority whatsoever for the position that the state must delineate or with nomenclature. So there is, and I did look. Maybe there's a case out there. If so, I'd like to see it. I have not been able to find it. But there is no authority that the state is aware of or that I have seen cited by the defense that says that to be a sufficient allegation in the indictment that a RICO count charge must delineate these are predicate acts. And, Judge, in that context, there is a case, Brown v. Friedman, 222 Georgia Appeal, Georgia App 213 on page. I'm sorry.
How about just the fact that an indictment has to enable the defendants to prepare for trial, and if they don't know what predicate acts that make up one of the 3 counts, if they don't know which acts are going to get their clients in trouble for that one count, how are they able to prepare? They've got to guess how many out of 225. Because, like I said, if there's 5, then they got to knock out 4. If there's 200, then they got to knock out 199. But they're left to guess.
And Judge, I would go back and I'd come back to Brown, but give me 2 seconds to find.
Especially where a predicate act doesn't have to be a criminal act. That makes it even harder to show with just there are no elements to put in there. You know, what's the element of a criminal act? Well, it's not a criminal act, it's a predicate act.
Judge, and I do not have this the entirety of this case in front of me. However, I think this case was cited by the defense. 303 Georgia App 183 at 186.
Hold on a second. 303 Georgia App.
Yeah. Yes, sir. 183 at 186. And in candor, I do not have the entire case before me, but I have a quote from it.
State v. Bear,
Yes.
2010.
On page 186.
Well, you don't like the first sentence of
No, sir.
186.
I do not.
Which is the state's argument ignores important facts.
Yes. That's never pleasant for a prosecutor to hear.
Right. The test for determining the sufficiency of the indictment, is that the language you want me to read?
Yes, sir.
The test for determining the sufficiency of an indictment or accusation is not whether the charging instrument could have been made more definite or certain. Agreed. There's perfect and then there's perfect. Or for that matter, perfect, but whether it contains the elements of the offense intended to be charged and sufficiently appraises the defendant of what she must be prepared to meet, and in case any other proceedings are taken against double jeopardy. So this is the same language we've seen. Yes, this is.
Yes, sir, Judge. I'm trying to find the portion of.
Okay. And then it says, thus, if the accused can admit to all of the indictment or accusation or citation charges and still be innocent, the indictment or accusation is defective. That's as to a general demur.
Yes. Yes,
The
sir.
argument Mr. Samuel's partner was making was special demurs, saying, hey, where is it? Because it's general and special demurs to count one, insufficiency. I don't know which of these. He's saying, he's admitting some of these have criminal elements to them, but they don't satisfy the requirements because they don't have the actual elements in them.
Yes, sir. And
And I don't know whether it's a predicate act or not. It's a criminal act. I don't want my guy pleading to that. But is it predicate or is it just a benign overt?
so, Judge, and I'm struggling, but to locate where.
I agree with her for once.
But is it predicate or is it just a benign overt?
So, Judge, and I'm struggling, but to locate where in that particular case it says this, but I will assert to the court that there is established Georgia case law that says in assessing the sufficiency of the indictment, that you read the indictment and the allegations contained in the indictment along with the criminal statutes. And so, for example, and this goes into...
Although recitation of the statute may, in certain cases, be sufficient, though not may be a sufficient, though not desirable, method of apprising a defendant of the charges arising against him, recitation of portions of the statute is not sufficient if, reading the accusation together with the statute, a defendant is unable to determine which of his acts are alleged to be criminal in nature.
So that is one of the cases. So that
Insert the word predicate act for criminal in nature. Because there's a requirement of so many predicate acts, right? 2 predicate acts or 1 domestic terrorism, right?
yes, sir.
Okay. So if a defendant is unable to determine which of his acts are predicate acts, or alleged to be predicate acts,
Yes, sir.
is that not problematic?
I think it is not I'm just going to say it. I think it is not the best way. I think that it would be more clear, but I do not think that it is fatal to not identify them. And let me give you Brown, and I do have a copy of that whole case, Judge. Brown v. Friedman, it's a civil case, and so I understand that it's a RICO case and therefore has... Sorry.
Not for nothing.
Yes, sir.
You know how I read all their motions?
Yes.
I would have loved to have read some responses. And as Mr. Samuel pointed out, I had nothing to read from the state on this. Nothing.
Yes, sir.
And it's been 2 years.
Oof. Oof. Off. We're gonna rewatch that one. That was brutal. When the judge is quoting opposing counsel to you, shit went wrong somewhere.
Sorry.
Not for nothing.
Yes, sir.
You know how I read all their motions?
Yes.
I would have loved to have read some responses. And as Mr. Samuel pointed out, I had nothing to read from the state on this. Nothing.
Yes, sir.
And it's been 2 years.
Yes, sir.
Because I kind of pride myself on trying to come prepared.
Yes, sir.
So what's your Brown site?
The Brown site, Judge, is
That's the worst thing.
222.
Like, laughing aside, when she was getting laughed at, I guess this was also yesterday, but earlier in this hearing, that, whatever. It sucks, but this is a personal, you fucked up. this is bad. I feel bad. I feel bad for her. Like, I know it's her fault, but oh, I feel that pain.
Georgia App 213, and I'm gonna.
Like, I don't feel that bad for her, but you know.
There she blows. All of these cases cited by both sides all have big yellow squares, big yellow triangles next to them.
I will tell you that there was not a single one that I'm citing that you don't look, because it's all distinguishing, and so
And it's on other grounds.
Yes.
Well, again, all right, I'm on it.
So Judge 217, and essentially the reason I am directing the court to this is this was not particularly the primary issue in the case. However, in that case,
It's a summary judgment case.
it is a summary judgment case, and Brown contends that the trial court erred in granting the summary judgment to the defendant Friedman on the RICO claim, a RICO violation with a code section, and any subsequent recovery through another code section requires that Brown show an injury, a pattern of racketeering activity. A pattern requires at least 2 interrelated predicate offenses. Here's the important part. In her complaint, Brown does not expressly allege which of the acts she recites in her narrative of events constitute predicate criminal acts for RICO purposes. In her brief to this court and in her response to Friedman's motion below, she alleges theft by conversion, theft by deception, and mail fraud, which constitute RICO predicate acts. Although she does not specify all the acts which she alleges constitute these crimes, at this point she is not required to do so. Friedman can ask for a more definite statement. So
Friedman's not going to prison if he loses.
I said that it was a civil case right off the bat.
That's
And so, but my point is, Judge, that the only case law.
Friedman didn't face prison if you like.
That's correct. That's correct.
Last time I checked, there was no mandatory sentence on him.
Correct. Correct. And it's not mandatory on DT. I was about to say. So
With the agreement of the state. What, on domestic terrorism?
yes,
No, on racketeering it's 5 to 20, but the 5 can be probated.
Right.
I was wondering about
It's
this.
not mandatory prison time, but mandatory splitting hairs. It's not wrong.
There's no mandatory incarceration potential mandatory incarceration for Mr. Friedman.
That's true, Judge. I'm not
So-
disputing that. It started at the very beginning, said this is a civil case. However, there is no, again,
And at this point, she is not required to do so.
they're talking
Friedman
about.
may move for a more definite statement. We don't have that in the civil arena. What we have is a general and a special demur, and they are doing that. But you're not allowed to amend your complaint. You can't amend your indictment. Which is, so I think that's just easily distinguished away. So I'm going to close that window.
Yes, sir. Close that window. It was, and it goes back to, I looked hard, there is no case law that requires that they be delineated. I understand what your point
There
is
is
to the
case law
state.
that says they got to know what they're defending.
Yes, and
Lots of them.
and the state's position is that when you read the statute, which is a limited number of excuse me, when these lawyers or their clients read the statutes, which defines specifically what racketeering activity is, and it defines which racketeering activity, which criminal offenses can be racketeering offenses, and then it defines in subsection B a much narrower limitation of which criminal offenses, acts, or threats involving those criminal offenses can be the basis of racketeering activity, and that from that, when the state alleges that he participated in, and I don't have one in front of me because I just turned the page, but when there's an allegation in a paragraph in those 225 overt acts, and it says he did X, Y, and Z, facilitating an arson, or and the word arson is used, I think any rational person and reasonable person would know that that is an activity or an action or an allegation of an act or threat involving arson. So yes, I think
Okay, so then it's a criminal act, right?
it would be under B. So no, sir, we don't have to allege that. We don't have to allege an arson. We have to allege under B. We have to allege that they committed an act or a threat involving arson. And so when we say, let me find one, Judge, if you don't mind. Will you find one of the paragraphs that mention arson that don't charge arson for me, please? And Mr. Fowler's going to give me an example. Actually, 194. Hang on, I may have one. Okay. This is an example, Judge. 24 times from 194 through 217 alleges that on or about March 5th, 2023, insert name, 24 of the different defendants, did join an organized mob and succeed in overwhelming the police force, thereby aiding and abetting in the offense of arson. And then it's with purpose. So, I mean, with the attempt to occupy and prevent. Any person can read that and say,
Is this the arson that occurred back on January 21st?
no, it's on March 5th that he did join the organized mob to attempt. So reading it says, look, these folks got together, they organized a mob, they succeeded in overwhelming police and aided and abetted in an arson. And that was on March 5th.
Because the arson that's alleged in the indictment is from January 21st.
January 21st. And that is alleged in a different, there are facts, the facts supporting the overt acts and the racketeering activity is alleged for that particular arson.
Abetting the offense of arson. How are they supposed to know which act of arson they're defending against?
So I don't, first of all, I don't think that's where we get into, I don't think you have to allege that. It's just like that Dorsey case. Well, while I understand people may want us to have to, we don't.
Is aiding and abetting arson not a crime?
Aiding and abetting arson is a crime, but they are not charged with aiding and abetting an arson.
Yeah, but it's a predicate act that is a crime.
We're not,
Yes?
I mean, it can technically fall under aid, but that's not how we're charging it. And
We don't know because you didn't say.
I think it alleges the facts necessary to put them on notice that those are actions involving arson. And there are others.
What arson is going to be what they're going to ask? Which arson did they aid and abet?
The one on
Because the only one that's listed is the one on the 21st.
That's the only separate offense of arson,
Okay.
but it is not the only arson that's mentioned because it specifically says on March 5th they aided and abetted an arson. They're not separately charged with that, but
Can you show me an overt act in the list of 225 that just talks about arson? Because I'm looking, like I
It may
said,
be.
205 from 194 on.
I don't know if it uses the word arson, Judge. 2 seconds. Is arson used elsewhere in overt acts? Can you check for me?
Well,
And
again,
I can
how are they
look.
not
This is
discussing that?
yesterday's. I wanted to finish this one before.
I'm not trying to be flip.
Today's.
I'm genuinely curious.
So, Judge, to the one
I'm genuinely trying to understand what you're saying.
I'm talking about, the 24 that I'm speaking of,
Starting at 194.
starting at 194.
Okay.
I will mention, if we look at Dorsey, I understand the court's questioning and point with regard to that, but Dorsey did reject this idea. So in Dorsey, the defendant was charged with acts involving murder. Murder is also an A offense, under where you're actually charging a predicate act that is a criminal offense. Under A, you must set out all of the elements because you're saying they committed the crime.
Hold on a second. I'm looking at page 541 of Dorsey.
Yes, sir.
Dorsey challenges category 5 predicate offenses, each concerning act involving murder.
Oh, thank you.
No.
Okay, here's the difference though. I don't think I heard them say, Mr. Garland, correct me if I'm wrong, they're not arguing that that act can't be a predicate act. They're just saying it's,
Two different things. I understand, yes.
he's not challenging that that can't be a predicate act.
Not at this point, no, sir.
Mr. Garland, is that correct?
We need to know.
He's just saying we need to know.
And if it is, the indictment's got to tell us, not the state. The indictment's got to satisfy the requirements of the elements and the facts that apply to
Well,
it.
and what she's saying is,
That's what-
just like this said, an act involving murder, the state has said an act involving arson and terrorism, and domestic terrorism.
And Your Honor, I can wait till the state's done, but I
Yeah,
can
you
have
can.
a response to the
All right,
Dorsey
well.
case.
Go ahead.
Yeah, Brooklyn. It's just.
So,
It's just.
Judge, the other thing
funny
you had
thing.
asked me for other references to
being
arson,
silly.
another reference to arson is where one of the, and let me not be vague,
Please don't. Well,
you may want.
because I think that's what most of these folks here are accusing you of right now.
So the word arson is also mentioned in paragraph 130, which is one of the publishing a post on scenesnoblogs.org, claiming for responsibility for an arson and using that as a way of threatening.
So, whoa, them being in the forest and joining a mob in March is aiding and abetting an arson that occurred in Portland on January 1st?
No, sir. I am confused as to what your question was. I thought you were asking me to tell you where else in the 225.
How are they supposed to know which arson you're talking about? Because the murders in Dorsey, there was but one murder. There was but one murder. So an act, a predicate act involving murder. Everybody knew which murder they were talking about. We don't know, they don't know what arson you're talking about.
The allegation is that they attempted the arson on March 5th. So and did acts to attempt.
Dorsey's charged with a murder.
Yes, sir.
One body.
Yes.
Okay. Some of these defendants are charged with one arson that occurred on January 21st?
Yes.
Okay. And in March, they are accused of aiding and abetting arson.
Well, there's also accounts in the 225 that pertain to.
Those aren't counts.
Sorry, there are also paragraphs in the 225 listing of overt acts, which include predicate acts.
Is there even an arson that is alleged on March 5th?
There's not a separate crime of arson on March 5th.
But yet on March 5th they aided and abetted them.
Yes, because the underlying arson there is no venue for to bring in an indictment in Fulton County. We could not bring that as a separate account.
Wait, what? You didn't have venue for the arson, but you did for the...
Because this court lacks, in this county lacks venue over it as an individual or a separate offense. So we couldn't include it as a separate count.
I mean, I guess that's possible, but it's strange.
Okay. Because the fire was in the cabin.
Yes, sir. But
that might be information that they would have wanted to know about. Of this thing got burned up in this place. You may be 100% correct. Can't bring it as a separate account because it didn't happen here.
Yes, sir.
But it puts them on notice as to what they've got to defend against.
And Judge, the only thing that I can tell you is that I'm not going to sit here and argue that that more detail could be provided, that it couldn't be better or more perfect, if you will. What the state's position to the court is that there is no legal authority and there is no case law or precedent or persuasive case law that supports the position that us failing to identify which overt acts that are also included directly and specifically in our indictment as including racketeering activity, that by failing to delineate which are overt acts and predicate acts, there's no case law or authority that says that that is a demurrable flaw in the indictment.
Yeah, you also didn't read that case like 10 minutes ago, so talking about there's no case law is probably an unwise choice. Also, the issue, there was case law cited. They need to be on notice of how to defend. And the judge keeps saying that. That is case law. That is the law. They need to be able to defend themselves. And they don't even know what fire is being discussed in an arson overt act and active racketeering activity. So, I mean...
That's not
sounds like no matter which way I rule, there's about to be case law.
It's possible.
One of you is going to take me across the street.
Completely possible.
Before that.
So that is my position, Judge, and I do understand what the court is saying. I understand their argument. Why are you looking at me like that?
Just the brow is furrowed, that's all.
Okay. I didn't know if that had said something that you were questioning. So with regard to that issue about delineation and articulation, of which I think I've answered that.
Who's the alarm on? $50, charity of your choice. Send me the receipt.
Sure. I'm supposed to take my son to climbing.
All these people have climbing gear.
So in the indictment, a bunch of people were alleged to have climbing gear. That was very funny.
That was humor, y'all. Sorry about that.
Did he just make everybody laugh after charging somebody $50 for...
Go ahead.
Thank you, Judge. I just need to respond to a few more things. Let me make
Before
sure.
he has to go stone something.
It's the overlook, excuse me. I would never go stone something.
Go ahead.
Too much. I've already presented that to you. Okay, so there was arguments in the defense made that, for example, anything in claim in part one could be a predicate act, and Judge, I just quickly and bluntly, it just doesn't that lacks basis, because it's clearly delineated that it says, and the following are going to be or alleged to be overt acts and furtherance of the conspiracy, and some include.
Oh, you're addressing their concern about how do they know they're going to have to defend against stuff coming in out of part one?
Yes, I'm sorry if I didn't say that well. But there was a lot of things said, and I'm trying to make sure I hit them without dwelling. So I'm trying to begin back at the beginning of their argument, and that is where they started, essentially. And the point is that it's very clear and is delineated in the indictment when the allegations regarding overt acts, which include predicate acts, of racketeering activity begins, and that is the language that has been stated, but it's
okay.
part two.
Let me read you the chunk of language before part one.
Before part one?
Yep.
Yes, sir.
The end of, you got count one, racketeering.
Yes.
Lists all 61 folk. For said accused, individually and as persons concerned in the commission of a crime, and together with unindicted co-conspirators, in the state of Georgia and the county of Fulton on or between May 25th, 2020 and August 25th, 2023, while associated with an enterprise, did unlawfully conspire and endeavor to conduct and participate in, directly and indirectly, such enterprise through a pattern of racketeering activity in violation of 1614(4)B, as more particularly described below and incorporated by reference as if fully and set forth herein, contrary to the laws of the state of Georgia, good order, peace, and dignity thereof. Part one, the enterprise.
Yes, sir.
So all the facts in the enterprise are incorporated into count one. You stand before me saying, hey, Judge, we're just talking about those 225 acts. I'll take you at your word. They can't. They got to take the indictment as written.
Which says introduction, the enterprise, and one of the elements we
It
must
says
prove.
part one, the enterprise.
And then it gives an
A, introduction.
Yes.
B, defend the Atlanta forest.
Yes.
Anarchy background of defend the forest. Beginnings of defend the forest. Public Safety Training Center. Shadowbox Studios. Cat County land swap. These all have facts in there.
Facts? Yes, sir.
Okay. That defend the Atlanta forest overview. Defend the Atlanta forest funding. Now, and we run into the whole money laundering issue. Communication. Talking about signal, telegram. Entity amount totaled $48,000. Occupation inside. There are facts, and yes, obviously we're going back to however many centuries. That's a little different than, hey, propaganda and recruitment. Are they going to have to defend against this?
Defend against it in the context of an overt act?
In the
No,
context
it's not
of, is there an enterprise? Did they use these things to build an enterprise? Is there indeed an enterprise?
Then yes, Judge. Any and all evidence we have at our disposal to establish and to show that this group of individuals were associated in fact and that they had a common purpose to commit racketeering activities. Any admissible evidence to prove that, absolutely, they should be prepared to defend against it. If it's not admissible, the court will say that they don't have to defend against it. But as far as whether there was an enterprise, 100% the defense should be prepared for every single fact that we can use to establish the association of this group of people, how they were funded, how they recruited. Sure, we have to.
But none of that.
Yes, Judge, it is in there. Recruitment. Let me let you finish your sentence. Excuse me.
I'm now into your 225.
Well, now that's a separate issue because all of that goes to the enterprise, and the indictment clearly delineates that. Part one, I think is how it says, under count one, elements of conspiracy. Then part one, the enterprise. It is defining the enterprise, describing the enterprise, whether eloquently or with violent political rhetoric, depends on who you talk to. But regardless, the bottom line is, it is in fact, that is where the indictment says each individual charged in this indictment knowingly joined in the conspiracy. Conspiracy contained a common purpose. So it fully lays out everything. And while I'm here, it also lays out the nexus. It affirmatively avers that, and I think I've said this, but I'll say it again, defendant in the Atlanta Forest is a self-identified coalition and enterprise, blah, 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 and that organizes, organization coordinates, advertises, conducts direct action designed to prevent the construction of those things and promote anarchist ideas. This self-proclaimed direct action has included, and then it lists the various things, vandalization of private property, arson, destruction of property, tax on law enforcement. Anyway, so the point is, while I'm there, that is the nexus. It affirmatively argues the nexus. And then we get to all of the other things that are alleged about the description, because we must prove and allege enough detail to establish the enterprise. And Mr. Fowler's already talked about why the history and things of that nature are.
So are they going to have to defend against masked folks making statements? That was raised by the defense.
If it's admissible, yes. And the state is going to say that some of those things are admissible, yes, sir. If a co-conspirator that we can establish, our co-conspirator, produces propaganda that talks about different things about this conspiracy, and I know people throughout the confrontation clause, in no way is it testimonial, in no way. So if we can establish, because it's not testimonial, because it's not made, this is well before any type of arrest or prosecution, so there was no possibility that it was gathered for the purposes of litigation. If we can meet the elements of admissibility, that's the reality of it. But that's true of any situation, Judge. The state is going to use any and all fact that the state believes and can show furthers its proof of various facts in the case. And if those are admissible, yes, they should be. Now they're going to argue that they're not admissible. We will argue that they are, and the court will decide what comes in the end. But yes, any and every piece of evidence we have that establishes, well, for one thing, when it began, when the conspiracy started, when they started making plans, when they began the occupation of the force, all of those things for the very reason of what we've been arguing about today, for one thing. It all becomes relevant. So that is part one.
Sorry, I was just confused. I was wondering how the statements of a masked unknown person could possibly establish anything with respect to these specific defendants.
And to go back to how they know that part one's not is because part two says it. Part two delineates and specifically says that they committed. You see it. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. So, and this is no offense to anybody, but I think it's disingenuous to say that
you're in dangerous territory. I would be very careful right now.
It ignores the language of the statute. Let me just say that, or the indictment itself, to say that we don't know whether or not the part one is also the overt acts and the predicate acts, because the indictment, while it could be better and it could specify which one of the overt acts are racketeering activity, definitely it could, and it doesn't. It does delineate what acts we are saying are or could be or they might have to defend against. And then when you look to the statute, it is further limited. Not every act is going to, for example, the money transfers. Those are overt acts in furtherance of the conspiracy, allegedly. That's what we say they are. However, that in no way falls within any definition. It doesn't fall within the statute. It's not an arson. I mean, it's not related to arson. It's not related to murder, robbery, kidnapping. It's not an act or threat. It's not with one of the one of the crimes, I need to slow down, one of the crimes under the 5A. And so, no, I mean, but it does require that analysis. So the state's position, Judge, is what I've said. And then as far as whether or not there are other aspects, one of the things that they have alleged is that we have not drawn enough, or we haven't alleged, and they've said it in different ways, but one of the arguments is, and Mr. Samuels said it, and I think...
I'm going to go ahead and say you shouldn't call somebody disingenuous if you're just going to word salad, because you're just going to look like a jerk. I know what she's trying to say, but my goodness.
It's been said multiple times is they don't even say for example, they don't say my client did an overt act did a predicate offense. He or she is not charged, it's not charged in this crime or that crime. And I'll just say, Judge, we don't have to allege or prove that. We'll go back to Mr. Liberto since he's been the star of the day. That Mr. Liberto or any particular defendant charged in this indictment, we do not have to allege or prove that they ever committed a predicate act or that they ever agreed to commit a predicate act. And bear with me, Salinas v. State, and I know I should have Salinas v. State, Salinas versus United States.
federal RICO statute case.
And that is 522. And I do have a copy of any of these you want.
522.
US 52.
No, she's not right about what she just said. She's close. You don't need to allege that each defendant committed an overt act, but you do need to allege that they agreed to participate in the conspiracy to commit predicate acts. So that the second half of what she said was wrong.
Figure out what page that is. One second,
Salinas
Judge. I
versus
need to
United
correct you.
States, 1997. Yeah, it's just a different statute. Federal statute. It's a Texas case.
Don't have it.
Yeah, I mean, she's not that far off. Like, the statute is really general.
Sorry, Judge, for the delay.
But she took it like one step too far.
Another yellow distinguished case. Just want to make sure I reference the correct page number.
This is why you respond to, you do a written response.
It's going to be there. It's going to start, Judge, I think, on 62. Get to the correct quote. If conspirators have a plan.
She's 63.
Okay.
So there's a portion of it, Judge, that quotes to United States v. Holt, and that's 236 U.S. 140. And the Salinas Supreme Court says, if conspirators have a plan which calls for some conspirators to perpetrate the crime and others to provide support, the supporters are as guilty as the perpetrators. As Justice Holmes observed,
That's not what
plainly,
he said.
a person may conspire for the commission of a crime by a third person. A person, moreover, may be liable for a conspiracy even though he was incapable, of committing the substantive offense. And that's cited to Rabin.
Yeah, but you still have to agree to participate in whatever way you do, even if it's not a crime.
Page 6. I don't see that on page 62.
I may be on the wrong page. Let me find it. It's in there.
This is why you write a response.
Conspiracy may exist even if the conspirator does not agree to commit or facilitate
Yes.
each and every part of the substantive offense. The partners in the criminal plan.
Each and every part, meaning you can agree to some parts but not others. That's totally fine. That's not what she said, though.
Must agree to pursue the same criminal objective and may divide up the work. Each is responsible for the acts of the other.
Yes, sir.
If conspirators have a plan which calls for some conspirators to perpetrate the plan and others to provide support, the supporters are as guilty as the perpetrators.
Yes.
Plainly, a person may conspire for the commission of a crime
Just
by a
read
third
it.
person. A person, moreover, may be liable for conspiracy even though he is incapable of admitting the substantive offense.
That's page 64, 63 to 64, Judge. So yes, sir.
He knows what page it's on. He just read it. He can look at what page it's on. He doesn't need you to tell him the page number of what he just read.
Apologize. And continuing on in that same case, Judge,
If you continue to read what he just read,
it
I swear
rejects
to God.
the concept. In fact, they argue in this case that we should have to prove that connection, that each perpetrator or each defendant, was required to have participated or intended to participate to engage in or commit racketeering activity. And the court directly rejected that. And let's see, on page 65, towards the bottom, it says a conspirator must intend to further an endeavor which, if completed, would satisfy all of the elements of a substantive criminal offense under the federal statute, which is different from ours. But it suffices that he adopt the goal of furthering or facilitating the criminal behavior. He may do so in any number of ways, short of agreeing to undertake all of the acts necessary for the crime's completion.
Sure.
One may be a conspirator by agreeing to facilitate only some acts leading to the substantive offense.
Yeah.
It is elementary that the conspiracy may exist.
Yeah, leading to the substantive offense. You still need to show how the act would lead to the substantive offense. I think she's just taking this one step too far.
Be punished whether or not the substantive crime even ensues, because conspiracy is the distinct evil dangerous to the public. And this is where it, in the state's opinion, has particular pertinence to their argument. It says it makes no difference whether that the substantive offenses under the federal statute requires 2 or more predicate acts. The interplay between subsection C and D does not permit us to excuse, that's the conspiracy aspect of it, does not permit us to excuse from the reach of the conspiracy provision an actor who does not himself commit or agree to commit 2 or more predicate acts requisite to the underlying offense. So
yeah, but they still need to agree to the conspiracy. You need to conspire.
again, addressing the argument being that we had to allege in our indictment that the defendants either agreed to commit acts, predicate acts, or did commit predicate acts, that's incorrect. We do not have to make that accusation in the indictment. We do not have to allege that. We do not have to prove that. As long as they knowingly joined the conspiracy, and the conspiracy, the conspiracy itself has the common purpose of committing racketeering activity. And I quoted that to you earlier. So
that was actually really well put after the last hour, but that was a really good way to put it. You need to join in the conspiracy. Generally, you don't need to try to do any specific overt act or do any overt act.
Cited that to you earlier. In addition, I cited Thompson v. State to you earlier, which also supplies further makes the state's argument even more secure or more definite because it does not require, that's the case, Judge, that if you recall, and this is an important thing, we don't even have to prove that they had every knowledge, were involved in everything, that they knew all the facets of it, that they knew what all of the co-conspirators were going to do. As stated, what we must prove is that they intended and knowingly joined the conspiracy, and that
but you need to say how they did that.
the conspiracy had the common purpose. And that's what we have to prove, and we have explicitly alleged that in paragraph A of the introduction. So, as to that argument from the defense, it just doesn't pan out, Judge. They also argue that the criminal purpose to commit, that we have to allege and prove that the enterprise had a criminal purpose, and that, I don't know how much this was fleshed out in oral argument, but I saw it in the written, that the enterprise must have a criminal purpose, and that's just not an accurate reflection of the law. The law that I have cited to you already and read in court already explains that an enterprise isn't a crime itself, and that it doesn't have to be criminal. I mean, the enterprise, this grouping of individuals associated in fact, can be, in fact, illicit or illicit. So, and their activities can be licit and illicit. So the enterprise itself does not have to be a criminal, does not have to have in other words, they have to have the common purpose of committing, we have to prove, and we have alleged.
Licit versus illicit. Licit is, we've incorporated, defend Atlanta Forest, we are an enterprise. Illicit is, we're just a group of folks. There still has to be a criminal intent there.
Not in the joining, not they have to have a common purpose. And yes, as a group, as an enterprise.
And as long as that common purpose is a legal, legitimate thing, that's okay, right?
Until this group of associates conspires and determines or agrees to commit 2 or more predicate acts to reach their objective. Yes, then now we're getting into the RICO, and that's what's alleged.
So they commit criminal acts.
Yes. Yes, sir. Took me a minute to get there, but yes, sir. So I've already talked about the nexus. I've already talked about that. If you'll give me 1 second.
This is getting back to what I said at the beginning, the difference between alleging it against a specific person versus alleging the existence of a criminal enterprise.
I want to make sure. There's a lot of argument, and I've read and I'm not going to go through every single one, but there is a lot of argument about there's not enough here, there's too much there, there's not enough here, there's not enough there. For example, night of rage, or whatever it may be. The reality of it is, Judge, we have to allege sufficiently the elements of the offense, which obviously for the last several hours I have been arguing that we have. We do not have to allege every fact that they want to know. We do not have to allege how we are going to prove something. We do not. We allege the elements. enough so that they understand what's coming against, or that the charges against them, and that's really the point, and the charges they're going to have to defend against. And then the discovery, it shows them the evidence we're going to use, how we're going to use it and apply that evidence, what we're going to argue, what our internal mental thought processes are on prosecutors as to what evidence pertains to this and how we're going to prove that. That is simply not required in an indictment. And I'll give you an example, night of rage. They came down here for a night of rage. If we had gone into the definition and explanation and all the explanation about what a night of rage was, one, it would have no bearing on the fact that that was the overt act was alleged that they came down on a night of rage, which the evidence.
You just put night of rage in quotation marks. So what does it mean?
Will explain at trial, and they did X, Y,
They need to know before trial so they can prepare for trial.
and Z. If we had gone through 15 paragraphs talking about this night of rage and where it came from and how we know they called it and all the calls to do it and all the things that different co-conspirators, named and unnamed, put out there on social media to stir up and stir violence, then we would have been talking about political violence again, or rhetoric again. So it's...
No, you just need to explain what the event was.
And it's not
nonsense.
necessary.
Ridiculous.
We made an
It's a bad
allegation
faith argument.
of an overt act in furtherance of the conspiracy, and that's what we did. And there's no more detail that they're entitled to on those type of issues. So, let's see what these. And Judge, I'll give you one last little example. I mean, I need to wrap it up, but the many things that they think they want to know are simply not required to be alleged in the indictment. I'll give you an example. Criminal trespass. The term criminal trespass. It says that so-and-so did commit a criminal trespass. And there's a lot of motions filed and people arguing about that. He's not charged with criminal trespass. It's listed as an overt act. Criminal trespass is not one of the offenses under...
Yeah, but they need to know how they did the overt act.
1614.3.5a. So it's not a criminal offense. It's not a racketeering activity under B. And so it's simply a statement. Okay, now that he committed this in furtherance of, could it be more specific? Sure. But is he entitled, because we use those words, to a full recitation of the elements of the offense? The state says no, because he's not charged with the offense. If we were charging him with criminal trespass...
But you couldn't charge him with the offense because it happened in
Yes.
DeKalb County.
True, but we're not. So we have not alleged criminal trespass in our indictment as a crime, and therefore, and again, what we're talking about is what is demurrable or not, or whether the indictment is valid or not. And that is not a valid basis to invalidate the indictment in the context that he's not charged with it. So the requirements that we set forth, every element of it, just does not pertain. We generally said that he committed a criminal trespass. Now, they can argue whatever they want to the jury at that point. But that is one example. There are many others. But I think the court gets the gist of my argument, which is the details that are necessary, the details that define and prove, or allege, not prove, allege, with sufficient particularity that all of the elements, Mr. Garland did an excellent job of articulating those elements, that the indictment has done so. And that while it could be better, it is sufficient.
Okay. Your motion, Mr. Garland. You're up.
Okay. So even if we were to concede, which we don't, that the allegations of arson and domestic terrorism on January 21st satisfy general demurrer, that does not save this indictment from my special demurrer.
This count.
What?
This count or this indictment?
Doesn't save that. Even if that was enough to save the indictment from a general demurrer, it doesn't save it from a special demurrer, because the special demurrer doesn't identify those predicate acts in any way, and it doesn't
Are we
tell us.
talking about counts 2, 3,
It's
1?
counts with respect to Mr. Carroll.
Mr. Schwartz, he's up.
Counts
You
after.
delineated him. He's your guy.
Yeah, no, I understand what you're saying, Your Honor. There's counts 2 through.
There's 2 and 3. There's 1, 2, and 3. That's all we
Yeah,
got.
so counts 2 and 3, which allege arson and domestic terrorism. There's an argument under which those can.
Right now, we're talking about count 1 in this motion. In motion number 3.
Okay.
Right?
I'll abandon that because it's not essential to what I'm trying to convey. Is that this indictment fails a special demurrer. And State v. Eastman tells us
Count one, because that's the motion I'm looking at. Count
count
one
one of this indictment
does
fails.
not survive a special demur.
That's correct. And this is State v. Eastman, 9/11, Southeast 2nd, 484. It's a 2025 case.
Yeah.
By filing a special demur, the accused claims not that the charge in the indictment is fatally defective and incapable of supporting a conviction, as would be asserted by a general demur, but rather that the charge is imperfect as to form or that the accused is entitled to more information. That's what I'm focused on, Your Honor. The state, and the information we need is set out in OCGA 17-7-54 and by Kimbrough. We've got to have the essential elements. It's got to allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And it must allow the defendant to prepare her defense intelligently. So they've got to allege that. They don't necessarily have to do it as a separate count in the indictment, but they've got to do it in the indictment. They can't get up here and argue that they're somehow met. It has to be in the indictment. They've got to allege the essential elements and the facts supporting them. And they failed to do that for many of the potential predicate acts that we've discussed today. Assault, influencing a witness, obstruction, money laundering, and whatever other predicate act the state can dream up.
Can you help me on the quote on the site for Eastman again?
Yes. 911, Southeast 2nd,
Give me the Georgia one.
okay, 374,
Uh-huh.
Georgia app,
Yep.
120.
I wasn't even close.
Would you like me to pause, Your Honor?
Yeah, just
Okay.
one. Sorry.
Oh man, we're getting so close to
And
today's
that's at
hearing. I'm really
page
excited.
121.
Okay, so you're saying, hey, these predicate acts are criminal acts, I need my elements, et cetera, et cetera. Whereas I just heard from the state saying they're not charged with those. They don't have to give them the elements.
Well,
Because they're not charged with them because they happen in another jurisdiction.
I think that's a red herring, Your Honor. I mean, Kimbrough and OCGA 17-7-54 are clear. We've got to state the essential elements. We've got to establish the underlying facts, right? It's required by Georgia law. It doesn't have to be in a separate count. It could be in the overt acts themselves. They could set out the essential elements. They could set out the essential facts. But they don't do that, Your Honor. They don't do it for assault, influencing a witness, obstruction, money laundering, and whatever else they can dream up. The discussion of Dorsey and these 5B acts, it's not a red herring, but they're putting the emphasis on the wrong syllable in that case. These 5B acts are acts involving murder, kidnapping, gambling, arson, robbery, theft, so on and so forth. The list of crimes listed in 5B that could involve predicate acts involving those crimes. But Dorsey's interpretation of 5B is really just about how we count the predicate acts. It talks about acts, that the acts involving style of predicate acts can be their own separate predicate acts. So a series of acts involving another crime, can all be separate predicate acts, right? So in Dorsey, you've got the murder, right? That's one act. But then getting in the car, that's another act. Buying the gun, that's another act. These are all predicate acts under 5B. But what Dorsey has, that this indictment fails, is an allegation of the essential elements of the murder. Is an allegation of the essential facts supporting those elements, right? Dorsey is like, how many predicate acts are there in a murder, Judge? Well, we've got the murder, and then we've got the other acts involving it. But you got that murder. It's proved, it's alleged. The essential elements are alleged, and the facts supporting it are alleged. We've got it, right, in the case. How do we chop it up? That's what Dorsey's about. Here, we don't have the essential elements. We don't have the facts. There's nothing to chop up. We don't know what these acts are involving. They haven't identified them. They haven't set out the elements as required. They haven't set out the facts supporting it. So Dorsey is not a problem for this demur. Had my complaint been there's too many predicate acts, well then Dorsey would be a problem for us. But that's not my complaint. Is that they haven't sufficiently alleged the predicate acts at all. And they clearly did that in Dorsey without a problem. They established elements. They put the elements of murder in and the facts supporting them. So it provides no problem for our special demur. There was some discussion by the state about the allegations in part 1 of the enterprise. I've already discussed how it's both overbroad and lacks sufficient details, but as we've discussed, are those allegations of predicate acts because they're specifically incorporated into the overt acts that include the racketeering acts per the indictment? Does it include George Floyd? Does it include Rayshard Brooks? Does it include the masked man who was he involved in an act involving felony obstruction? We don't know. We can't know. The indictment doesn't tell us. And in regards, let's see. There are certainly things that this indictment doesn't allege that I want to know. And it doesn't have to allege everything I want to know, Judge. But it's got to get across some fundamental threshold so I can prepare a defense for my client. This indictment is a problem with the state's creation. It suffers as a result of how they drafted and indicted it. Georgia law prevents my client and all the other co-defendants from having to fight for their liberty based on an unintelligible indictment. And we ask Your Honor to grant this special order.
Okay. All right, ladies and gentlemen. See you tomorrow. Before we go, I know, Mr. Dejan, you were making some noise over there. Well, I want to do something next. It was my intent. Number 4 was the lack of prosecutorial authority.
Your Honor, I can wait till number 10. Order this for number 10.
Yeah, it looks fun. That's what y'all put the list together
Yes.
for. Okay, everybody wants to go to the front of the line. See you tomorrow.
Tomorrow's at 30 minutes, same time, same place.
Same back.
Okay. So now we get to the good part. We get to today.
That
I've been
time.
waiting for. Excitedly. So I'm going to show. Oh, here we go. I already have it open. Believe. I'm going to delete this real quick. Let's do this one. There we go.
Set things up,
Ooh.
as Your Honor's already noted and from reading the brief.
What's the volume? Is it loud?
Under the Georgia Constitution, the district attorney is the constitutional officer who generally has authority to prosecute criminal cases in superior court. In contrast, under the Georgia Constitution, and from our perspective, that's the important part of this, is this is a constitutional limitation. The attorney general has limited constitutional authority to prosecute criminal cases. And there's 3 instances the Constitution contemplates. Supreme Court for capital felonies, not applicable here. Skip on by that.
All right.
In all
Yeah,
civil or
actually.
criminal cases in any court when required by the governor, as Your Honor has already noted, I'm unaware of that existing. It certainly was not pled in the indictment. It's certainly not part of the record of this case. And then the last one is shall perform other duties as shall be required by law. What the Georgia Supreme Court has said is that as shall be required by law means as required by the Constitution or the statutes of Georgia. So fast forwarding, the RICO statute does not grant the Attorney General concurrent jurisdiction. As Your Honor's noted already, some statutes do grant that authority. Domestic terrorism is an example. Gang statutes an example. There may be other ones. I just use those as illustrative examples. But the RICO statute does not. Now, that's not the only way that the Attorney General can prosecute a case. There's what I would refer to as more colloquially as statutes of general or general statutes granting jurisdiction to the Attorney General. And those are mostly found in Title 45, 45, 15, and 3 and 6, and 18 and 10, and different ones along there. So most of those require the governor, again, back up. The legislation coming along has taken the constitutional limitation that all civil cases and criminal cases require the governor's authorization and has expanded that in some ways, as it's allowed to do under that last provision of the Constitution. And so in civil cases, the Attorney General enjoys a lot further latitude in representing the state in cases and pursuing civil cases. Criminal cases still largely limited by the governor's authorization, right? The one that I'm going to focus on, since we're jumping to the meat, at least what I believe is going to be the issue for the court to decide is OCGA 45-15-10. All right. And that statute authorizes the Attorney General to prosecute a criminal case without the governor's authorization when the defendant violates a criminal statute. And this, in my, I respectfully submit, is the key language here, quote, while dealing with or for the state or any of its officials, employees, departments, et cetera, et cetera. What I'd submit to the court is the court's decision is going to turn on what does, quote, while dealing with or for the state mean. That's a specific criterion. The way I'm reading it and the way I would ask the court to read it is a defendant must be, quote unquote, dealing with or for the state when he or she violates that criminal statute. It does not, I submit to the court, simply mean relating to the state or pertaining to the state. Legislature could have said that. It's much more of a term of art that they're using. So it's while dealing with or for the state, which means that the defendant could be either side on what appears to be some kind of a relationship equation. The defendant could be dealing with the state and being on one side of that relationship, and the state or the state entity is on the other side of that relationship. And in the course of that dealing with the state, commits a criminal violation. That would authorize the Attorney General to get involved. But the or for can easily get skipped, but it's a complete phrase. It's dealing with or for. And the or for, I respectfully submit, means that the defendant could be dealing on behalf of the state. So in the relationship equation, first one was defendant one side, state the other side. This
Okay, we can do the Atlanta Press Collective.
one, defendant.
Let me. This one, right?
Isn't that motion to dismiss and quash indictment / pleading abatement of indictment for lack of prosecutorial authority? Very interesting.
Your Honor's noted already, some statutes do grant that authority. Domestic terrorism is an example. Gang statutes an example. There may be other ones. I just use those as illustrative examples. But the RICO statute does not. Now, that's not the only way that the Attorney General can prosecute a case. What I would refer to as more colloquially as statutes of general or general statutes granting jurisdiction to the Attorney General. And those are mostly found in Title 45, 45, 15, and 3 and 6, and 18 and 10, and different ones along there. So most of those require the governor, again, in the constitutional limitation that all civil cases and criminal cases require the governor's authorization, and has expanded that in some ways. That's a lot to do under that last provision of the Constitution. And so in civil cases, the Attorney General enjoys a lot further latitude in representing the state in cases and pursuing civil cases. Criminal cases still largely limited by the governor's authorization. Right, the one that I'm going to focus on, since we're jumping to the meat, at least what I believe is going to be the issue for the court to decide, is OCGA 45-15-10. Right? And that statute authorizes the Attorney General to prosecute a criminal case without the governor's authorization when the defendant violates a criminal statute. And this, in my, I respectfully submit, is the key language here, quote, while dealing with or for the state, or any of its officials, employees, departments, et cetera, et cetera. What I submit to the court is the court's decision is going to turn on what does, quote, while dealing with or for the state mean. It's a specific criterion. The way I'm reading it, and the way I would ask the court to read it, is the defendant must be, quote unquote, dealing with or for the state when he or she violates that criminal statute. It does not, I submit to the court, simply mean relating to the state or pertaining to the state. The legislature could have said that. Much more of a term of art that they're using. So It's while dealing with or for the state, which means that the defendant could be either side on what appears to be some kind of relationship equation. The defendant could be dealing with the state and being on one side of that relationship, and the state or the state entity is on the other side of that relationship. And in the course of that dealing with the state, commits a criminal violation. That would authorize the Attorney General to get involved. But the or for can easily get skipped, but it's a complete phrase. It's dealing with or for. And the or for, I respectfully submit, means that the defendant could be dealing on behalf of the state. So in the relationship equation, the first one was defendant one side, state the other side. This one, defendant's over here dealing for the state in some kind of relationship equation. In that situation, the Attorney General can also get involved. It would suggest, I think, and strongly support that there's an ongoing relationship, and during that relationship is when the defendant violates the law. I'm going to pause. I'll tell you right now, if Your Honor, at the end of this, when we look at it, you decide, no, this means relating to or pertaining to, right? Which is what I say it does not mean. Right? But that's all it means. It's a much more broad, expansive jurisdiction for the Attorney General than we believe is supported by the statute. But that, to me, Your Honor, is fundamentally the issue that the court's going to have to decide. And we know from when interpreting a statute that the court will start with the plain meaning of words as they're commonly used and understood. So, in looking at Black's Law Dictionary, dealing means, and I quote, sixth edition of Black's Law Dictionary.
It is still going. We're on
means
today's.
transactions in the course of trade or business. Close quote.
But yeah, let's use
According
it.
to Merriam-Webster, dealing
Thanks for
means,
tuning in.
quote, method of business, manner of conduct, and dealings in the plural means friendly or business interactions. All right, these definitions, both from Merriam-Webster, which is commonly recognized as an authoritative source for the English language, as well as Black's Dictionary, that again is commonly recognized by courts and jurists and lawyers as an authoritative source for interpreting meanings of words. None of it's definitive, because the Georgia courts have also said we have to look at it in this context, but certainly persuasive, I would submit. All those are consistent with the phrase, dealing with or for the state contemplates some sort of business or transactional interaction between two persons or entities, and it's during the existence of those dealings the defendant violates a criminal statute. It is not, I think this is important, that the dealing with or for the state is in and of itself a criminal act. Right? It presupposes that some kind of relationship exists in some form or fashion. Now, the legal research I've done, I don't know if I should say surprisingly or unsurprisingly, but it's neither here nor there. There's not cases that decide this issue that I have found. Right? There's not really much case law out there at all. Right, one case that I have brought to the court's attention in a brief is Brown versus State, 177 Georgia App 284. Right, it's an example of an employee of the State Department of Labor who was prosecuted by the Attorney General for obtaining fraudulent payroll checks. That seems to be an example of someone dealing with the state, although as an employee, perhaps it was dealing for the state. The Court of Appeals does not address that language. Principally, the Court of Appeals does not address the language I submit because the record in that case reflects that the governor had authorized the prosecution. And again, when the governor authorizes the prosecution, then there's no motion for this. This motion doesn't exist, right? Once the governor authorizes the prosecution properly, then the Attorney General is allowed to go forward. We're here because there is no governor authorization.
Oh, I'm not sure
now
who this guy represents. Aaron might know if she's here.
Really, the one statute that may permit, or that I believe the state will argue permits it to proceed without governor authorization. We would submit it does not. Another case that's cited in the Brown case is Meredith versus State, 148 Georgia Appeals 853. It's another case, this one actually involves a private citizen, but it's another case in which the governor authorized the prosecution for the Attorney General. So although dealing with this issue in some form or format, it doesn't deal with it does not address the specific language of the statute that we're looking at, because in both cases, the governor had authorized a prosecution. So in preparing for this hearing, I then started looking at some other statutes that may have similar language to see if I could find anything that may aid the court, may aid all of us in deciding how to look at this issue. Right? And there's a couple cases I've come across that as an officer of the court, I want to bring to the court's attention. I'm not sure that either one of them provides us much in the way of dispositive information, but I think, Judge, in looking at this issue, if I know about the case and I think it pertains to it or relates to it, I need to let the court know about it. So one is Williams versus Bolton. It's a
I just want to show you this.
1971 case.
Oop. I just want to show you the statute real quick. Let me pull it up. There's this one. Yeah, it's this one right here. Power of Attorney General to prosecute in criminal courts and call on prosecuting officers. This one right here. The AG is the head of Department of Law, and the chief legal officer is authorized to prosecute in the criminal courts of the state any official, person, firm, corporation which violates any criminal statute while dealing with or for the state. So I guess the argument is going to be that this case does not fall within that scope, which makes sense to me. Let me see. Now I just got to find. Here we are.
Isn't there a case, forgive me, I don't have people subbing in for me every motion. It was, I think it was a woman, I want to say it was out of Gwinnett. The Attorney General brought the action against her, and I think the court reasoned that because it involved a grant from, like a grant from the state with state money, that authorized, that was the dealing for or with the state.
So I'm going to do a little guessing here, but this may be the second case I was getting ready to tell Your Honor about, and that's a different Brown versus the state. That is at 268 Georgia Appeal 629. It is a Gwinnett County case, and it involved, in fact, a woman who was investigated by the Attorney General. She had been running a nonprofit and received a grant of $10,000 from the governor. So that's the second of the two cases. That's a different statute. So it's not 45-15-10. It's 45-15-17 and 18.
That allowed them to investigate. Would he or she be intrigued?
Yes, Your Honor. Yes, Your Honor. But to me, it's a fair case to look at, and that's why I'm bringing it to the court's attention, although it looks like the court already knew about it, because it's within that same realm of statutes that deal with statutory authority of the Attorney General. So 45-15-18 has to do with the prosecution, and she challenged the case saying, well, they investigated me without receiving a governor's authorization. Now, before they indicted me, they got the governor's authorization, and so at that point, we're no longer dealing with a non-authorized case because the governor authorized it before the indictment, but after the investigation had already gone forward. And in that case, and this is what I want to bring to the court's attention specifically, and I have a copy of the case if Your Honor would like a copy. Okay. So, in addressing that issue, it says Brown, and Brown in this case is a different Brown with the defendant, obviously, maintains that because the governor did not issue the directive in this case until shortly before she was indicted, the Attorney General's investigation was unauthorized. Right? And then it goes to OCGA. OCGA 45-15-17A authorizes the Attorney General to commence investigation into matters related to the state, and the investigation to Let's Act began with the governor's grant of $10,000 to that organization on September blah, 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 blah. Okay? And it says thereafter the Attorney General's investigation was permitted under this code section. Finally, we reject Brown's argument that the Attorney General should not have been allowed to prosecute the case as, and it cites the code section 45-15-3, subsection 3, provides that the Attorney General will represent the state in criminal actions when required to do so by the governor, which of course has been occurred in this case. And so it's a different statute, but it has similar language with respect to the investigation. It's dealing with an investigation, not a prosecution, but it has language dealing with in there. Now in that situation, Ms. Brown had some kind of transactional business relationship with the state. It's not clear from the facts of the case, but it appears that she had reached out and either applied for or sought or some way obtained a grant from the governor in the amount of $10,000. And the court, in fact, specifically said, I already reported this to the court. Specifically said that the investigation began with the governor's grant of that money
That was from the
to that individual. And it appears because it was a fraud prosecution that there was some kind of fraudulent application or something in the inducement or somehow in obtaining that money, it was subject to a criminal violation. So that's the closest I have found. Again, different statute, but same kind of topic area, and therefore something I would like, the court should consider. Again, it doesn't really fit our facts for two major reasons. One, Ms. Brown has an ongoing relationship of some variety with the state, and during that relationship, is some kind of, is alleged to have committed a criminal violation, one. Two, different statute, and really three, the prosecution was authorized by the governor. So I know what we really are looking for, and I've been unable to find, and I certainly have tried, Your Honor, is some case in which it's not authorized by the governor, and yet the state's allowed to proceed under a theory of just somehow relating to or pertaining to. And that case, as far as I'm aware, does not exist. So again, our position is that the language dealing with or for the state, it has a specific meaning. It is not what I would refer to as language that you would normally use in a statute if you're trying to grant the Attorney General just general criminal jurisdiction anytime the state is an alleged victim of a crime. It has to do something more. It seems much more focused on entities or persons who are doing business with or somehow engaging with the state, and during the course of that relationship have committed or alleged to have committed some kind of criminal violation. Based on some arguments that the state raised at the Isla King matter, where I was not present.
It's funny, there are a total of 6 cases in the last 50 years that cite to the statute.
My understanding of these arguments is that the state may try to argue, so I'll go ahead and address now in the interest of some brevity in moving this along, that the damage to the Georgia Public Safety Building, which happened back in July of 2020, qualifies as dealing with or for the state, such that that would subject that act to the jurisdiction of the Attorney General. I think the easiest answer and the most straightforward one is that those defendants who allegedly committed those acts were not dealing with or for the state. They had no ongoing relationship or business transaction with the state. That is a situation where the only interaction, as I understand from the allegations in the indictment, was the actual damage done to the Georgia Public Safety Building by those individuals or those defendants, allegedly, and there's no other kind of interaction or connection between the two. That would be much more if Your Honor were to rule against me and say, well, Mr. Hall, like the argument, but this is really, it really means relating to or pertaining to. That would fall much more into that category. It does not meet the statutory criteria of dealing with or for. Kind of as a side note, if Your Honor were to go down that pathway and decide, well, I think it's broader than what Hall is telling me here, or the way that Hall is reading it, I would note that the public safety building occurred in July of 2020. That was months and months and months before the Atlanta Public Training Center was ever announced. And so I think, as Your Honor had already noted yesterday during the Demur arguments, it's really hard to imagine you can have a RICO conspiracy, which is defined as a RICO conspiracy to prevent or stop or cease the operation or building of the Atlanta Police Training Center when it wasn't even in existence at that time. I think most of all, and then secondarily what I note is that if the Georgia Public Safety Building is the government's theory or the state's theory as to why it has, that act has invoked the limited jurisdiction of the Attorney General, then it should have been pled in the indictment. It's not pled in the indictment. We're left looking at an indictment that requires you to plead, and these are constitutional jurisdictional requirements. We know it's constitutional because the Attorney General has limited authority. And so if you're going to say that some event qualifies as dealing with or for the state, you must allege, I would submit, sufficient facts and otherwise alert everyone that this is your basis to invoke the jurisdiction under that statute.
Do you have any cases where it involved leaving it in the indictment?
No cases on point as to this statute. The ones that I would use by analogy, Your Honor, are cases involving venue.
the guys, sweetie.
We may all know Atlanta Police Department generally, or Fulton County Police Department generally responds to cases in
I just want to say, I love this argument. I love these technical arguments. Like, I know it's going to win, or it's close to winning at least. I love this. It's fantastic.
Fulton County, you gotta plead venue. It's not up for debate. Venue's not pled and proven. It's a defective indictment, it fails at trial. Another example would be statute of limitations. If there's an exception to the statute of limitations, then again, it has to be pled and if necessary proven at trial that the exception for the statute of limitations applies or the statute was told. So the answer to Your Honor's question is no, I don't have a specific example as to this statute of this invocation, but by analogy, there's other constitutional and statutory requirements where specific pleading is required in order to survive a challenge like this, a motion to dismiss or a plea in abatement.
Well, and you go back and, did that happen in the indictments in the Gwinnett Brown case?
I don't know the answer because I have not pulled the indictment. I don't know the answer. I also don't know whether that issue was raised, a failure to plead or not.
Well, it didn't appear that, I didn't see that in the opinion,
Yes.
but I also didn't see the charging document was not in, it didn't discuss whether or not it was pled. It just said there was a previous authorization from the governor.
Right.
Post-investigation or pre-indictment. Didn't say one way or the other whether it either A, was contained in the indictment or B, needed to be contained in the indictment.
So I certainly don't know the answer as to the former, as to whether it was in the indictment in the second Brown case, the Gwinnett County case that we were discussing. Okay?
Or any of them.
Well, all right, I'm going to add on to that just a little bit, Judge. In the first Brown case, and I'll get you the site right here, I'm sitting here, let me finish my thought.
177 Georgia Ave, 284.
Okay.
I think that's what you said.
Yeah, in that case, so our position is it needs to be pled or included as part of the indictment. In that case, though, the Court of Appeal noted simply that it had been somehow made part of the record. So certainly with respect to, was it some way, somehow, this is the governor's authorization. Our position is it needs to actually be pled or otherwise introduced into the record. The Brown case certainly does not say that it needed to be pled. They noted that that information had been included within the record. So, did I answer the court's question?
The answer is you don't know.
Correct. I don't know as to what happened in the Brown Gwinnett case. As to the second one,
You don't know what those indictments say one way or the other.
Correct.
You
That's
don't know if
correct.
it was pled. in the
Correct.
indictment.
that's right. The other thing that they may
I would
argue,
be curious to see.
yes, Your Honor. The other question, or another point that the state may raise is the Atlanta Police Training Center also somehow provided a general basis for the Attorney General's jurisdiction. Kind of the same response, Judge. There's no ongoing relationship between the defense and the state such that they.
The law doesn't say in Title 45 or where the state is the victim of the crime, is your argument?
Correct. Right. I'll also note that APDC, to use the Atlanta Police Training Center, is not a state entity, it's a municipal entity, and nothing in the indictment alleges otherwise, which again, I would submit is important if somehow they're claiming that something about the indictment allows them to invoke the jurisdiction over 45-1510, it needs to either be pled in the indictment, is my position, or at a minimum under the Brown case that ends with page number 284, it must somehow be introduced into the record, at least with respect to the governor's authorization. And then the last point that they may make is that the Atlanta Solidarity Fund, or some variation thereof, was a 501c3 Georgia registered company corporation entity. And what I would say is that the mere existence of being a registered Georgia corporation does not authorize the Attorney General to exercise criminal jurisdiction over a company. In fact, if we stop and think about that, if that were true, then every single registered company in the state of Georgia could be prosecuted by the Attorney General's office, and I respectfully submit that there's no reading of 45-15-10 that would support such a broad expanse of the AG's limited constitutional jurisdiction. And again, as with the points I made with the other one, which I understand Your Honor may or may not agree with, but let me go ahead and make the point, is that no allegation in the indictment makes any reference to ASF being an entity or place that's dealing with or for the state, which I believe and submit as a necessary allegation. So those...
Although he's going through each possible way that the indictment could connect to the state to be something that deals with or for the state, and just cutting off each one before the state even has an opportunity to respond.
Would be the points I would make. There's one, I think, additional point I'd like to make in wrapping up here, and it's more thinking broader about this case as well. So I would say that even if the court were to find that the damage to the Georgia Public Safety Building or the Atlanta Solidarity Fund somehow invoke the Attorney General's criminal jurisdiction, and to be super clear, and I know Your Honor already gets this, as I say, being overly redundant, I guess, is we don't agree that it does. But if Your Honor finds differently, and to rule differently on that, then we certainly don't think that the AG's limited authority permits it then, based on those discrete instances of jurisdictional authorization through a statute, to glom every other defendant you can think of into this prosecution using those limited charges. Basically, what I'm saying is there's no ancillary jurisdiction in RICO cases in this state. The Attorney General doesn't have ancillary jurisdiction. If we have any doubt about that, we can just look at the RICO statute itself. It does not grant the Attorney General concurrent jurisdiction. Could have. We know the legislation knows how to do that. It did not do that. And so for that reason, I would say that
Yet.
yes, yeah. That's all public policy matters. The General Assembly may change something at some point. But as of right now, they don't have concurrent jurisdiction. And because of that, even if Your Honor were to rule against me on the limited basis of those different discrete events, that does not allow them to add in everyone else into this RICO theory. So under all those reasons, I respectfully ask that you dismiss count one of the indictment as to Mr. Carroll, Mr. Juergens, and every other defendant in this case.
Just out of curiosity.
Yes.
Count 2 is domestic terrorism.
Yes.
In the code, it says AG has concurrent jurisdiction.
Yes.
What does that do with count 3? Arson. I believe it's arson, right? Does that affect count 3?
Well, I would say two things. I didn't move on count 3, number one, but to the extent that they don't have a concurrent jurisdiction over arson, then yes, that would also go out the door.
Okay. All right, state's up.
Yeah, 20 minutes of argument. It was pretty definitive, I think. I just want to let me point out one thing. So this was while they were talking, I pulled up. Let's see if this will show. Yes. So this was when the motion was filed. It was November of 2023. Before the previous judge, Kimberly Adams. So the state has had years, well, just shy of 2 years to respond, or to prepare to respond. So this should be good, given how much time they've had. Where are you? There we go.
Good morning, Judge Farmer. And if I may begin by saying I'm appreciative of Mr. Hall, my colleague on the other side. He covered a lot of the issues that I was going to go over too, and a lot of the things he said I think were pretty fair recitations of the current status of the law in the state of Georgia. So I'm appreciative of Mr. Hall covering a lot of the things that I took a look at as well. And let me start with this. I agree with him about domestic terrorism. We have obvious jurisdiction over domestic terrorism. But
So I gotta make it a little louder for me. I don't hear particularly well. Hopefully that's not too loud for you guys.
turn to 45-15-10, which is the, if you will, dealing with statute. And to read the full statute to the court, and I think the court may have it in front of it right now.
I do.
It is that the Attorney General is authorized to prosecute in the criminal courts of this state any official, person, firm, or corporation. So we identify who the...
Oh, this isn't going to be good. I can already tell it's not going to be good. He just repeated the thing that the guy who went before him said like 800 times.
Who the accused will be right
Yeah, it was raised 2 years ago. It was November 2023.
there at the beginning of the statute, which violates any criminal statute, which could be felony, misdemeanor, whatever that it is, while dealing with or for the state or any official employee, department, agency, board, all of that sort of stuff. So what we have is we have an authorization of a defendant to be prosecuted, and then it lists anybody dealing with, and it's funny because Mr. Hall sort of followed the same logic that I did when looking up what dealing with means.
With or for.
Pardon me?
With or for.
With or for, correct, with or for. And you know, it's interesting because I found other definitions of dealing with as well, which is, quote, conduct in relation with others. That's dealing with as well. So for example, if there was an attorney that didn't like a judge, they may leave the courtroom and say, and someone sees them and said, what's going on? They say, I'm dealing with Judge Smith right now. That doesn't mean that you're conducting some sort of transaction with them. Or you say, you know, you don't look well, what's going on? I'm dealing with a sickness. There's all kinds of definitions. And the legislature did not give us any kind of guidance whatsoever. I looked for legislative history. I looked for all of that to figure out what they meant by that. There's nothing in the history or anything like that. So we have to take the common sense and the natural reading of it. And the natural reading of it in the state's position is that the natural reading of it is that when you're dealing with something or you're dealing with someone, you're dealing with whatever whatever relationship that you have. There are a lot of different relationships that there can be. Now, in that relationship, it is the state's position. I couldn't find any case law about this, but even if it was this way,
We get to be a case of first impression. Yay.
is that the state can't create the jurisdiction of the defendant. I believe that the defendant would have to invoke the state's jurisdiction. It must be a defendant's action.
Well, let's start with this. Do you have a governor's authorization?
No.
Okay.
No. And that's why the Brown case doesn't apply. I saw the Brown case as well, and oddly enough, later on I'm going to talk about a different Brown versus the state, even though there were two other ones that. So I'm going to talk about a different Brown versus the state. But here we have multiple times when the defendants invoke the state's jurisdiction. On page 49 of the indictment, the very first overt act, if I can point the court to that, it talks about attacking Georgia State Patrol headquarters. And it says right there, Georgia State Patrol. It's the state of Georgia right there. Now, by doing that, they're dealing with them right there by attacking the headquarters. Now, and it does say as well, it says any department, Georgia State Patrol, agency, Georgia State Patrol, institution, Georgia State Patrol.
So this would be one of the overt acts that predates the entire Atlanta Forest movement. I suspect that may be why these overt acts are part of the indictment. That makes sense now. It gets them. They're trying to get them jurisdiction. It makes absolutely no sense because it has nothing to do with the Atlanta Forest, which is the enterprise.
And so at that point, they invoke that. I would note that council also brought up the Network for Strong Communities, also known as the Atlanta Solidarity Fund. You can kind of use them interchangeably, but that's a discussion for another day that takes a long time to talk about, sort of the interplay there. But that they did register with the Secretary of State. And they did, and they invoked the state's jurisdiction there as well. Now, the question that I think that was kind of dancing around at Mr. Hall was...
So everybody who registers, every business that registers with the state is submitting themselves to the criminal jurisdiction of the Attorney General?
Yes. Yes, because I think the question kind of dancing around there is how much do you have to kind of deal with the state to cross into that threshold, right? That's really what I think the court is getting at. Paul is kind of dancing around a little bit, which is, well, there's not that much here. But how much do you need?
Did that 501c3 ever receive state funds?
Not that I'm aware of, Your Honor. But you don't have to.
That would have brought us back to the second Brown case.
Pardon me?
That would have brought us to the second Brown case.
Well, I think it's a difference from the second Brown case. But I don't think that you need to receive funds to do so. All you have to do is deal with the state. And when you register with the state, when you're a 501c3, you have to send paperwork back and forth. You have to send them information, they send you information back. You have to pay a fee to the state to say, I want to become a corporation. And they send you paperwork back that says you are a corporation.
You don't want to become a corporation. You just don't want to pay taxes on the money. You don't want to be a 501c3. If people could do it without becoming a 501c3, they sure would.
And I completely agree with the court about that, but that's exactly how the state can assert its jurisdiction over it, right? If people can't do it, is it permits the state not just to regulate, but to assert its jurisdiction over that. I'll give the court a different example when it comes to the Secretary of State. The Attorney General is, for the most part, the lawyer for state agencies. And there are times when they're not, but again, separate issue. But we can represent members, we can represent the state or the Secretary of State's office in civil matters. And so what I'm saying there is this, that if that's true, let's say there's a civil matter that comes up with the Network for Strong Communities, where they're suing the Secretary of State. The Attorney General can represent the Secretary of State. Why is that? Because it's a state matter. Because it's a state matter is the reason why.
The Constitution gives them the right to do civil stuff.
I agree.
We're not talking civil stuff. We had some analogies to civil cases yesterday.
Yeah, not to mention that even if you, like, the enterprise isn't limited to any specific corporation. It's a self-identified yada, yada, yada. Yeah.
I don't know that those necessarily translate into the criminal arena.
Correct, I somewhat agree, it kind of depends on the situation. But point being though, that what is the threshold of dealing with the state?
So when you register with the Secretary of State, you are submitting yourself to the civil jurisdiction of the Attorney General. You bet, sure. The criminal jurisdiction, on the other hand, different kettle of fish.
It depends, I think, on if,
Yeah, so
I'm not going to say that if someone who is Saturday driving their personal car down the road, going to, I don't know, Five Guys Burgers and Fries, and commits a traffic infraction that has nothing to do with...
On a state road.
On a state road.
On a state road, not county highway, on a state road.
I'm not entirely sure at that point that you're necessarily dealing with the state.
You're driving on state property.
It's not, I mean...
Just like the Georgia State Patrol building is state property.
I agree with you about state property, but they also threw a Molotov cocktail into the building while there were people present. And so that's another thing that invokes the statute as well, is it talks about employees of the state as well, where there were people present inside the building that had to go to the hospital.
So you get in a traffic accident with a Georgia State Patrol vehicle on a state road.
I think that's a little bit closer at that point. I really do, because at that point, if you cause the accident, and again, the defendant would have to invoke it, because if you were rear-ended by a state patrolman, then at that point, I don't know exactly what did an open container in the other person's vehicle. At that point, they haven't invoked that jurisdiction. But
if you're speeding on a state highway and Georgia State Patrol hits you, and you get charged with fleeing and attempting to...
I suppose it's possible, but at that point, I'm not sure you're actually invoking the dealing with the state by driving on their road, right? So, but here, they invoke it by Secretary of State, by attacking the Department of Public Safety headquarters. And I know they talked about the Atlanta Public Safety Training Center just being for the state or just for the city of Atlanta, but it's not. It actually trains state.
Judge, I apologize to my counsel, Mr. Fowler. I am a little worried we're getting to what came up yesterday about proffers I'm objecting to. So I'm going to object to any proffers that are being offered for evidentiary reasons. My apologies to interrupt. I really hate interrupting counsel's argument. If he's just talking illustratively, it's one thing. If these are meant as substantive evidence for the court to consider, I respectfully object to this. And
whether or not who owns the training center?
Yes. Yes, and what the funding is and all that. None of that's in the indictment. None of that's in the record.
Whether or not it trains people is different than who owns it.
Right, as well as the people inside of the Georgia Public Safety, and we're starting to get all these extraneous facts. So I wouldn't even raise.
I'm going to accept his proffer that inside the Georgia State Patrol building, there were Georgia State Patrol men and women.
Fine.
I'm going to accept his proffer on that one.
Yes, sir.
So I would also point out to the court another example on pages 99 and 100 of the indictment as well. It talks about different defendants who are engaging with an employee of the state government. That's Trooper Jonathan Salcido. And again, Trooper Salcido did not engage them. They went to his house in Bartow County. And so what we have there is, again, evidence of other defendants engaging state employees on their own. And so we're starting to see this constellation of these defendants engaging with the state again and again. And so what we also, so we're starting to see this
Do
constellation.
you not have with the state? I mean, let's say the Attorney General wanted to help the trooper take out a TRO in a civil arena.
Well, I don't think that, because that's not prosecuting, and this statute requires prosecuting the criminal courts.
Mm-hmm.
And so I don't think that this statute applies there because, like you said, that's civil.
Mm-hmm.
So I don't think you could do that.
You're subjecting yourself at the very least to a civil action brought by the Attorney General.
Potentially, I'm not entirely sure of our civil jurisdiction. I'll be honest with you, Judge. I would go to one of our civil lawyers. But I'm talking about criminal jurisdiction here, and you're talking about a civil TRO. And so when we're talking about 45-1510, and maybe I misunderstood the court's question, when we're talking about 45-1510, we're talking about criminal prosecution.
Right.
And so by engaging with the state, engaging with state officials, engaging with state employees, engaging with state agencies.
What I'm saying is, I agree with you, you're subjecting yourself to the jurisdiction
Right.
in the civil arena, but are you in the criminal arena? Are you dealing with them to the extent that you are dealing with or for
Yes.
the state? Clearly you're not dealing for the state.
No, I don't think there's any instance where any defendant in this case dealt for the state.
So you're dealing with.
Yes.
So you want that with to mean pertaining to versus in some sort of contractual or business relationship, which was, I think, Mr. Hall's definitions from Black's and Merriam-Webster's. Which dictionaries did you use?
You know, I wrote down Merriam-Webster. I'm not sure that I did use Merriam-Webster. I think it was just sort of and you can look it up now, I think that was just kind of a note to myself, like, hey, it was a dictionary. I may have used dictionary.com. I don't know which one that I used, but I can give the court the quote. But you asked about pertaining to. I think the closer one would be one that Mr. Hall used that I made a note on it. He said engaging with the state would be the closest one. And so engaging with the state is clearly what happened. They engaged with the state in various ways. And so the question
Engaging with is different. There was certainly
the dealing with? I think it would be closer than pertaining to. And I say that with respect to the court, disagreeing with the court.
Merriam-Webster. Dealing. Method of business, manner of conduct. Dealings, plural, friendly or business transactions. Let's see, also. There were reports of shady dealings between the two sides. It's a reputation for fair dealing.
So if I may, you can actually look up the term deal with as well as a phrasal verb on Merriam-Webster. The first definition is to be about something, to have something as a subject. And so I would respectfully suggest to the court that looking up for going to Merriam-Webster would be deal with as opposed to just the term deal. Because I think the term deal with is a term of art that is in 45-15-10. And the first there is to be about, to have something as a subject.
The OED makes you buy a subscription. And I do not have a subscription for the Oxford English Dictionary.
I do not either, Your Honor. But again, kind of going back to the notion of how much do you need, one thing I would suggest to the court is that in the indictment, we have multiple instances of what we title in our legally known overt acts. And so I don't know, there is no case law that I can find on this as to what the standard for how much you need or how much you need to interact with the state. But I would suggest to the court that this is sufficient. An overt act, at least one overt act has to be conducted to engage with the state. Now, again, I don't have any case law to back that up. I also don't have any case law to say that is not enough. But there's more than one overt act in this indictment that suggested that these defendants interacted with the state. When we're looking at how much, though, how much do you have to interact with the state? I did kind of take a little bit of a broader survey of, like you said earlier, we don't like to compare it to civil, but I didn't know where else to look other than kind of those jurisdictional hooks. In the civil world, when you are trying to bring someone into a civil lawsuit, a single event is sufficient to impose jurisdiction over an out-of-state defendant. And that's McDonald versus Roy E. Beatty and Associates. It's 203, Georgia Appeals 807. Behar versus Aero Med International 185, Georgia Appeals 845. In addition to invoke the jurisdiction of the Superior Court, all you need is a single felony. You don't need more than one. Here we have multiple overt acts. When we take a look at the federal criminal jurisdiction, all you have to do is you don't even need to make an overt act. All you have to do to invoke the federal criminal jurisdiction is cross state lines. That's all you got to do. You don't have to commit a crime. You don't even have to commit an overt act. All you got to do is cross state lines. And so when we take a look at that kind of that broader survey, I think what we see is it's a pretty low bar. When here what we have is we have the defendants affirmatively dealing with the state, affirmatively engaging with the state in every way, as not just alleged in the indictment, but also outside of the indictment as well. Now, one thing that I do want to address that I respectfully disagree with my colleague on the other side about is he indicated that it needed to be pled in the indictment. I respectfully disagree, and his examples were that you have to plead venue, you have to plead, and I believe the statute of limitations were the things that you had to plead. And the reason that you have to plead those in an indictment is because they're material elements of crimes. You have to prove venue, you have to prove the statute of limitations. Those are statutorily required as part of an indictment. This is not statutorily required as part of an indictment under the OCGA. Instead,
More analogous to a civil suit, jurisdiction pursuant to whatever statute or whatever code section, or why you're in the Superior Court has jurisdiction for this because of X, Y, and Z, versus your garden variety indictment doesn't say the attorney general or the district attorney has jurisdiction to do this because it says so in the Constitution.
correct. It doesn't say because there's a felony here, here's your indictment. I agree with the court about that. So the final thing that I will move to is I respectfully disagree with
But it does have to be somewhere in the record if there's a governor's authorization.
Yes, there does need to be, in some way, shape, or form, something about that, and that's why we're here today. The final thing is I would respectfully also disagree with my colleague on the other side about the remedy here. And so going back to the first Brown case that we talked about, that's the 177 Georgia Appeals 284. I agree that it doesn't apply insofar as to the analysis under 45-1510, because that involved a governor's appointment and all of that sort of stuff. There is one small area where I do think it is important, and that is the acknowledgement, because the case is almost 40 years old, is the acknowledgement that a plea and abatement is the proper vehicle for this motion. I agree about that, and that is alleged in this motion, but I'm getting somewhere with that, which is this. There's a set of, well, I know there was another Brown versus State that was discussed earlier. There's a third Brown versus State here. It's 295, Georgia 240. It's a Supreme Court case, and it talks about there are two kinds of pleas and abatement. And there's a proper effectum, and there's proper defectum. There's two different kinds. And it was in the discussion of a grand jury presentment and whether a grand jury presentment should be quashed or whether it should continue going on with just the problematic part kind of cleavered off, if you will. And what it talked about, it kind of sounds exactly what it sounds like, which is effectum, does it affect the process, or defectum, is it a defect in the process? And there's a difference that results in the remedy. Proper effectum would be something akin to a grand juror that has a vested interest or an inappropriate interest in the grand jury proceedings. So in other words, they can't be fair and impartial. Proper defectum was when a grand juror was not statutorily authorized to be on the grand jury, such as someone who's not a United States citizen, doesn't live in the county, doesn't meet the age requirements, or something like that. In Brown, the Supreme Court said if it's a proper affectum issue involving whether someone can be fair and impartial, and I think the example that they used there was that a couple of the grand jurors were related to the victim or maybe the defendant, something like that. They said the entire thing has to go away because it was taken from the beginning. In the defectum
They can
area,
talk.
which is I think more akin to what we have here, because if it's someone who shouldn't have been here, the answer is that in that case you have to clear that part off, and it just abates, and it's plea abatement. The indictment, it just stops until someone else takes over, which I believe the proper, if this court were to rule against this, which of course I don't concede would be the district attorney's office. And so Bonnie Willis's office would take over and prosecute this case. I believe that under Brown versus the state.
Or Sherry Boston?
Well, she can't because she's not the district attorney of Fulton County. So of course, she could bring those charges in DeKalb County if she wanted to, whatever venue is over, she could do that if she wanted to. She has concurrent jurisdictional role.
We heard a lot about why there weren't certain counts because we didn't have venue yesterday. So, you know, Bonnie Willis has jurisdiction over the crimes that occurred in her, but you're gonna say she could take over the RICO? But does she just take over your indictment?
I
Or
believe
does she
so.
start fresh?
Under the Brown case, I don't think the indictment
Or
is
do,
quashed.
or do we cleave count 1 and count 3 and leave you with count 2?
I don't believe so, Your Honor. I don't, because that would be quashal of the counts, which is what Brown talks about is not appropriate under the defectum. It's proper under the affectum.
But if the Attorney General didn't have the authority to bring the indictment, doesn't that make the indictment a legal nullity from the get-go?
I don't believe that's what Brown stands for. And you know, I would point the court to another case, and I don't have the site off the top of my head. It's the Lample case, I believe about 16 years ago out of Clayton County, maybe 12 years ago out of Clayton County, where an individual testified before a special purpose grand jury. The trial court found that the testimony given by Mr. Lample in front of the special purpose grand jury was outside the scope of the grand jury. And when the Supreme Court ruled, they said, you're right. And as a result of his testimony, he was charged with perjury. And so the Supreme Court said, you're right. His testimony was outside the scope of the special purpose grand jury. And they said, you're right, that testimony should not have come before the special purpose grand jury because he couldn't have been there. But the answer that the Supreme Court gave was, but your remedy is not quashal of the count. The remedy was you continue on, and it's not a problem with the indictment. And so, yes, Your Honor, go ahead.
I'm reading your Brown case, the 295 Georgia 240.
Yeah, whoever said they were talking a lot about remedies was right. Art Nixie?
They admit that part of their observations are dictum, so they're pontificating. So that case is about removing grand jurors.
Correct, it is.
So the analogy here would be removing the attorney general.
I think so. I mean,
But if you remove the attorney general and say he didn't have the authority to do what he did, I'm having a hard time saying, okay, he wasn't allowed to bring this in. But he did, so we're just gonna go with it. We're just gonna hand it off to somebody else. The constitutional officer for prosecuting here, the DA, who may or may not have brought that accusation to start with. So can the AG go in, bring an indictment, knowing he can't do it, I'm not accusing him of that.
no, I know that.
Knowing he can't do it, but forcing a case upon a district attorney? And therefore making the district attorney make some sort of political decision of whether I'm gonna take it and run with it, or do I turn around and look at the AG and go, I'm gonna not cross your indictment.
If I may just, I don't want, the word isn't take issue, but if I may just kind of parse. Discuss is a great word. One, I can't imagine, and certainly anybody I would.
I'm trying to ride the slippery slope both ways.
Sure, of course. Would take a case intentionally into grand jury and do that just to pawn it off on someone else. I can't imagine it.
Okay, but like I said,
Second.
that's all the way at the bottom on my slippery slope.
Right,
Okay.
right. I just, because of the way it was worded, I just want to be sure that.
Let's say he accidentally did it. Well, ooh,
Sure.
dang it, I shouldn't have done this one. Here you are, Madam or Sir DA.
I think that's what Brown tells us. I really do. And I understand the court's logic. It's not as though I'm looking at the court thinking, how is the court getting there? What is he thinking? But I'm going by what the Georgia Supreme Court has told us is what I believe to be the appropriate thing. But all of that said, we don't need to get there because we have jurisdiction. These defendants have invoked the jurisdiction of the state, not just in the indictment, but also outside of the indictment by engaging with the state. They've engaged with employees of the state. They've engaged with institutions of the state. They've engaged with agencies of the state. They have done that. They have dealt with every single one of those. And when you take, not just look at deal, but deal with, under Merriam-Webster, to be about something, to have something as a subject. And we talk about it in the indictment. We talk about, just the plain language of.
Okay, but dealing with usually implies, common meaning, a two-way relationship. There's a one-way relationship here, as alleged by the state. These folks did these things to the state, okay? There's no dealing with, it's doing to.
Well, I don't.
You're not dealing with, you're not looking for an exchange of ideas or an exchange of commerce or any kind of exchange. That was a one-way exchange.
Well, let me give the court the first example on Merriam-Webster of how they use it in an example. The one that's to be about something or to have something as a subject. It says, here's the sentence. Her speech dealt with healthcare and the nation's economy. And so that's that. They're not engaging necessarily there, but it is a single one-way street in the example that Merriam-Webster gives us, which is exactly what the court just said just a moment ago, is it's a one-way street. And so that one-way street, under the Merriam-Webster definition of deal with, actually is exactly what the court is talking about.
But if we take that definition, their act of throwing fire at the GSP building dealt with the state?
I mean, in a lot of ways, judges, I stand here.
That doesn't deal with the state.
I mean, in some ways, if you actually read the indictment and talk about anarchy and all of that sort of stuff, they are dealing with the state in the same way that if your kid makes you mad, in some way, shape, or form, and you say just colloquially, I'm going to go deal with this. That's exactly what they're doing right there by dealing with the state. And so, yes, I mean, we can talk about it in a number of different ways, but I think the plain language way that we talk about it under Merriam-Webster and without any further definition, that yes, this is exactly what this means. The plain language of the statute is exactly what it means. It can be one way, it can be two ways. It includes doing business. It does. If they had said, does business with, then I think we would probably have a completely different analysis here. But they didn't include that language. Instead, they chose the language deal with. Deal with, not do business
But
with.
you want the analogy to be any instance where the state is the victim of a crime. You would say anytime the state is a victim of a crime, that's what your definition of dealing with is.
Yes.
But if you read it, and if it just said dealing with the state, maybe, but let's, dealing with or for.
Yes. If you shoot a state trooper, you bet.
Dealing with or, well, then you got a capital crime. Okay, and what are your,
Yeah, I think the judge is right here. Adding the or for kind of means that dealing with can't be the colloquial usage of, just dealing with something. It means like having deals with something or having deals for the state. Man, this is not going well for John here.
at least going to get there in front of the Supreme Court because the Constitution said so. But dealing with or for, I think both of you kind of focused on dealing with. But if we're dealing with or for, that is, isn't that more of a analogy to a business relationship?
No, I think what that does is it kind of flips around, you're dealing for the state, so at that point, it makes you an agent of the state. So for example, if I were to go out and commit a crime on behalf of the state in my job, I start, a little more difficult for me as a prosecutor, but if I was somebody who worked over in budgeting and had access to money, and I started doing some sort of illegal contracts and bid rigging with somebody, I'm dealing for the state, because then it would be a little bit more difficult to say you're dealing with the state as a state agency, or as a state agent, and dealing for the state covers that, where state employees are doing something wrong as well. So that's what that is. And so, yes, if you, and when I said shoot a state trooper, I understand the court talks capital, that the court's aware the trooper was shot in this case. He's survived. After multiple surgeries, he survived. Because he's deceased now, but someone who was camping in the woods shot a state trooper. And so, yes, we are dealing with that as well here. And so, when
Well, not this indictment or not.
well, partially because Mr. Toronto's dead, who shot the state trooper.
Okay.
But it will be relevant to, in case.
Well, I mean, under your theory of conspiracy, doesn't that make all 61 of them?
In theory. But it comes in any ways relevant to explain why some of these crimes were committed in response to it. But anyway, engaging with the state. If you shoot a state trooper, yes, you're dealing with the state. So long as he was within the course of his duties, all of that sort of stuff. Absolutely. You're dealing with the state. And I don't see how you wouldn't be dealing with a state official or a state employee, right? And I'll give the court another good example. Let's say that there is a traffic stop. You talked about transactions. There's a traffic stop and someone tries to pay off the state trooper. Might be a transaction there. Let's say the state trooper takes it. Be able to prosecute that, certainly. Because it was dealing with the state. And so it doesn't, and this is not limiting anybody to any kind of economic transaction. It doesn't limit anybody to any sort of business transaction, nothing like that. It simply says dealing with the state. And the legislature meant what they said and meant what they wrote and wrote what they meant. And here, that's what they wrote. They wrote dealing with the state. So if you are dealing with the state, and going back to kind of you don't have to have much at all. There's no standard here to say you have to have 2 overt acts, you have to have this, you have to have that. You only have to have a small hook. Just like if you're committing what would otherwise be a federal crime, and you drive all the way up to Trenton, Georgia, and then you step over into Tennessee, and then you come right back, suddenly you have invoked the federal jurisdiction by crossing state lines. You don't have to go 100 feet, miles, 6 miles, 12 miles. You only have to do it a little bit. Here, they did it, not just a little bit, they did it quite a bit. GSP headquarters, shooting a trooper, Trooper Salcido's house, as alleged on page 99, 100 of the indictment, and page 49 of the indictment. These defendants dealt with the state. That's what they chose to do. And when you deal with the state, you invoke the jurisdiction of the state.
Okay, so what about counsel's argument regarding the ancillary jurisdiction? And
Regarding,
bringing in the instance of primarily the GSP headquarters, and I understand you have later on with Trooper, using that as the catch-all for all of these other folks? Same calculus, same argument?
Yeah, I mean, it's the same argument, right? It's a conspiracy, and it's the enterprise that is engaging with. As part of it, they are conspirators, and that's the way it's alleged, as co-conspirators as part of the enterprise engaging with the state here. I mean, it's a pretty straightforward argument. I think I can expand on that. I know the court probably understands what I mean by that.
Yeah,
But if you take a look.
super expansive reading.
I'll take a look at what page it is, and I was looking at it earlier. It's page 49, I think. If I may just scroll.
The overt acts start on page 49.
That's exactly where I'm headed, Judge. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below, including all defendants. And those include all acts of racketeering, because when you're responsible for one, you're responsible for all. And so, for that reason, it includes all the defendants here. And they did in multiple instances, and I think that's helpful. I mean, is it required? No, but I think it's helpful that they did in multiple instances engage the state themselves. Not the state engaging them, but they engaged the state on
That's right,
multiple
James.
instances. And so, you know, I don't think it would work to say that, oh, there was only one incident where they accidentally engaged the state. I don't think that would survive, but I do think it's helpful for the state's argument to add on to say that they engaged the state multiple times. So there's no accident here. They intentionally engaged the state. They intentionally engaged state employees, institutions, agencies, all of that sort of stuff. All in the name of, as alleged, as part of the conspiracy, in the name of anarchy and all of that sort of stuff. And so they do engage the state for that reason. And so for those reasons, we would ask that the court deny the defendant's motion. I know I'm kind of wrapping it up right now. If the court has any further questions, I'm not trying to avoid them, but happy to sit down if the court's finished.
No, I want to hear back from Mr. Hall. Thank you, Bill. Mr. Hall,
Yes, sir.
are you not dealing with the state when you make the state a victim of a crime?
You are not used, and the state is not powerless in any of those situations. The easiest answer is the district attorney, constitutional criminal prosecutor for that county can prosecute, or you solve all these problems with the governor's authorization. In fact, every single example of the cases that both I and Mr. Fowler on behalf of the Attorney General's office have brought to you involved exactly that, where the governor stepped in and authorized it. So this is not a situation where, if Your Honor does not follow the state's reading, that while dealing with or for the state has to mean relating to or pertaining to, or the state is a victim, the state is something powerless to fight crime or combat injuries. They have all kinds of tools for that. You get the district attorney to prosecute it, you get the governor to authorize it. And every single example we've seen on reported decisions, the governor in fact has authorized it. Not just involving state employees, including attorney general prosecutions against private individuals. So it's not like it's hard to do or difficult to do. It wasn't done in this case. So I would urge you to avoid taking the statute and expanding it beyond its plain meaning. On that note, I would say,
Well, I mean,
Yes, sir.
dealing with has a much more, it has an expansive array of plain meanings.
so yes, if you include the colloquialism deal with. I agree. If this phrase, and the phrase again, the complete phrase is while dealing with or for. And so, as Your Honor's already pointed out in talking with the state, and I'll just reemphasize this, that phrase has to be taken as its whole. You can't just take the deal with and ignore the or for, because it's all part of how it's defined to give what's otherwise limited constitutional jurisdiction to the AG through a statute. But if you look at, if you just were to take the colloquialism, deal with, and you can say that all the time. I dealt with my child today. I played soccer and I dealt with a difficult attacker, defender, coach, whatever the case may be. We use deal with.
Yeah, it's the or for that informs the rest of it. What a nerdy argument. I love it so much.
As a colloquialism in all kinds of ways. When it comes to a statute, I would respectfully submit, however, in the statute where it specifically says while dealing with or for, it has to have a much more narrow meaning and one more akin to the definitions I provided to the court from Merriam-Webster and Black's, which it envisions some kind of ongoing relationship, a business relationship, a transactional relationship. I'm seeking funding from the governor to get some grant. I mean, on that note, you know, Georgia corporations are not generally subject to the Attorney General's criminal jurisdiction. Now, if that entity is engaging in some kind of business or some kind of ongoing transaction with the state, and while dealing with or for the state in that capacity commits a crime, that's a different proposition, but that's not what we're dealing with here. The mere status of being a corporation does not make you while dealing with or for. Your Honor asked briefly, I'm going to keep going, if I did not answer the court's question, I want to make sure I answered it.
Keep going.
Okay. So the court had asked a question, well, I don't know if the court asked the question or it just came up in the discussions of the state about the civil jurisdiction versus the criminal jurisdiction. And that's addressed by the legislature in OCJ 4515.3. Specifically, the Attorney General has been granted the authority by the legislature to represent the state in all civil actions tried in any court, period. In contrast, in that same, that's subsection 6, in contrast, in that same statute, when dealing with criminal cases, it says when required to do so by the government to participate in, on behalf of the state, all criminal action in any court of competent jurisdiction. So it's a very different granting of power. I mean, in the absence of the governor's authorization, which is undisputed, does not exist here, we're left with 4515.10. And again, if deal with the colloquialism is what this means, then yes, it's much more of a relating to any time you even sneeze towards the state, it would probably qualify. That's not what the statute says. It's not a colloquial phrase. I think it's not a colloquial phrase for a few ways. We can look at that. But it specifically focuses on while dealing with, or as Your Honor's noted, or for. And it's not two different meanings. It's the same thing. And it has to mean,
I love it.
Has to mean too strong, but I certainly believe it means some kind of business or relational transaction relationship going on. The other point I'd like to make is...
Okay, to Mr. Fowler's point.
Yep.
Somebody shoots a state trooper, and it's not a capital.
Yep.
Okay?
Yep.
Can the Attorney General prosecute that individual?
Not under 4515.10. No, they cannot. It is not while dealing with or for the state. It is not. Can they prosecute them? DA can ask, Attorney General, we'd like you to come in. Happens all the time. Across all the counties in the state, happens all the time. Metro counties, rural counties, governor can authorize them. They can come in that way. The Superior Court judge of that, chief judge can ask them to come in. There's multiple statutory vehicles to get the Attorney General in. But the Attorney General, in that situation, in the hypothetical, where the Georgia State Patrol officer has been shot, not killed, and is alive, and subject to an aggravated assault.
So we don't bring the capital issue.
I've just avoided that based on the hypothetical, but yeah. But just, there's no issue of capital anything involved in it. The Attorney General cannot use 4515.10 and say, I'm just going to prosecute it. Lots of ways for the Attorney General to prosecute it, and certainly if they felt like the DA was not up to the task, lots of ways that they would prosecute it. But no, under 4515.10, that is not while dealing with or for the state. Otherwise, it would just be any time relates to the state, or any time you cause an injury to the state. And the legislature, we would say, generally knows what it means and means what it says. And so we would say, in that situation, if they wanted it to be broader, then they would have made broader language. And again, we start with the proposition that this all starts with a limited constitutional authority for the Attorney General. I mean, one way to solve all this is the Constitution could have given the Attorney General concurrent criminal jurisdiction as with district attorneys. It doesn't. General Assembly could have gone in as they did with civil actions and given concurrent jurisdiction with the Attorney General for district attorneys in all felonies, all misdemeanors, all criminal actions. They did it. And so they certainly know how to do that when they want to give a broader expansion of jurisdiction. And we know that multiple ways, but one of the easiest ways is under 4515.3, subsection 6, where they give the Attorney General the jurisdiction to represent the state in all civil actions in any court. That's the easy fix. And therefore we can say, because they didn't do that, they intended a more limited, much more limited grant of jurisdiction to deal with situations where someone has some kind of ongoing business, transactional, whatever it is. I mean, charitable, transactional relationship with the state, and while that is ongoing, commits a criminal offense. And then at that point, the Attorney General can come in. It doesn't require the governor's involvement. That, the General Assembly said, no, that's enough, we can just get the Attorney General in on its own initiative. Otherwise, the governor can always give authority to anything that he or she deems proper and appropriate. I would also say, Judge, that I do not agree with and would object and dispute this idea that jurisdiction in this case can be based on overt acts under RICO. So if the court were to find that the dealing with, while dealing with or for the state is more like pertaining to or relating to, and not what I'm asking the court to read it and as my reading of that statute, it nonetheless, there's no, first I would ask the court not to find that, but if the court finds that no, it's more relating to or pertaining to, then that still doesn't allow them to bring those cases, that's jurisdiction over crimes, not over overt acts. And all that's been alleged in this indictment are a variety of overt acts. And as we went through yesterday, some of them are crimes, some of them are not crimes, some of them are properly pled as crimes. Well, I think none of them are properly pled as crimes because they don't have the elements. And
Okay, you're losing.
sorry.
Because if the Attorney General has the authority because somebody dealt with throwing a firebomb at a GSP.
Yes, sir.
Okay, so they now have jurisdiction over that. If that person is part of a conspiracy, you're saying the AG then doesn't get jurisdiction over the conspiracy, just over that one individual act?
Yeah, yes, if we're talking about the conspiracy, yes, assuming that we're past this whole while dealing with or for business, we're
Let's
past
say-
that. You've said no Hall, it's regarding or touching upon whatever.
Right. So if he's got jurisdiction as to one, does he not have jurisdiction as to all in the conspiracy?
Well, I would say the answer is no, okay, number one, because, excuse me, let me back up.
If the person who throws this thing
Yes.
is part of a corrupt organization,
Okay.
okay, how does the Attorney General then not have jurisdiction over the other folks in that corrupt organization?
What I would say is that if you find if you find that with the dealing with or for,
Am I asking that right?
yeah, you're asking it right, I'm not answering it right, you're asking it perfect, I understand your question. So in that situation, the bomb thrower would be subject to, or Molotov cocktail thrower, whatever you call it, would be subject to jurisdiction, given this way that we're talking about, hypothetically. And two, I would agree that people who are part of the conspiracy to throw that bomb, Molotov cocktail, whatever it is, would also be fair game because as co-conspirators of that act, they would be within the umbrella or ambit of that authority. I would not agree, however, that would extend to include everyone in a RICO case, because in that situation, all we have is this ancillary jurisdiction that I'm objecting to, where they're saying, we have this act over here that gives us jurisdiction.
That is part of a broader conspiracy. So we're gonna take jurisdiction over the whole conspiracy.
Yeah,
That's your argument.
yeah, I would,
Mr. Fowler?
It is your, yes.
I would draw the line there. As to a traditional conspiracy, as to the act itself, yes. As to the fact that that act is pled as not even as a predicate act in this case.
Well, we don't know, do we?
We don't know, right. But let's assume hypothetically, it was properly, to get to what I think of the court's asking, if it had been properly pled as a predicate act, then yes, I would say that that would not extend to the
To
entire.
the other overt acts?
Yeah, that's correct. That's why I would draw the
You
line.
only get the parts of the conspiracy where the state is the victim?
Correct, yes. I understand you may not agree, but otherwise what you're doing is allowing them to just say, we have one thing over here in July 5, 2020, the Georgia Public Safety Building incident.
The
And we're
members of this conspiracy, by committing an overt act against the state, have given the state, the Attorney General, jurisdiction over the whole conspiracy.
Okay.
I think you're in an all or nothing situation.
Okay.
Yeah, I don't follow you on that.
Fair enough. I appreciate your candor to me. That's fine. I'm gonna move on that point. And
Okay.
I just respectfully, I draw the line there. I understand you disagree with my point.
You disagree with me, I get it.
Yes, sir. There's a comment that was made about whether there should be pled in the indictment, the Attorney General's,
How they came to have jurisdiction.
yes. And I don't have a case on that point. I would say, though, that in the example that
Yeah,
the
exactly,
state
Donna.
gave, and I may be mismatching, maybe your honor, whoever gave the example of a traditional indictment with the district attorney involved.
That was me.
Yes, sir. So, of course, the district attorney has general constitutional authority, so it's not an issue, right? The only reason this would even be an issue with respect to pleading is that there's a limited jurisdiction for the attorney general, and it's a constitutional limitation. And so when you're saying that my constitutional limitation doesn't apply, then I would say, Your Honor, respectfully, it has to be pled in the indictment in some form or fashion.
So you're saying that Gwinnett indictment, after the investigation, where there was a governor's authorization, that indictment would have had to have said, the Attorney General is bringing this action pursuant to authorization from the governor.
Yes. I don't know if it did. I don't think it was raised. I can't tell you what it says because we discussed, I don't know what it says. But yeah, my position would be, if you're trying to expand your constitutional limitation on jurisdiction, we can't just assume because you've shown up with an indictment, it's okay. It's got to be pled, no different than venue or statute of limitations or anything else. Not true for the district attorney because they have a general criminal jurisdiction.
But you have no law or case law to back that up.
Zero. It's by analogy only, Your Honor.
I think as long as they can show it so that it survives the challenge, that's, I'm not convinced as of yet that it has to be pled in
Yeah.
the indictment.
Yes, sir.
I would be curious to see a couple of those indictments. I think we all are a little curious now
Right.
to see, was that even done? Because if it wasn't, and it wasn't raised, then you are the first brilliant man thinking this.
And I'm
Because
just
because the other folks missed that issue entirely.
It wasn't even my idea. I'm just, managing
You're the bag man.
idea. So I'm just one showing up with the argument. And then the last point I wanted to address, and then I'm again happy to answer any questions the court may have, but nor do I want to overstay my stay, which I like I've already done. But let me just end on this.
I'm here every day, Monday
Yes, Your
through
Honor.
Friday.
Yes, Your Honor. I do not agree that a plea and abatement motion to dismiss which we have filed, that the remedy, if Your Honor were to agree with us, is to keep the indictment active and bring in the district attorney for Fulton County. The analogy, to use the Brown case that Mr. Fowler cited, I believe would be that if it's an analogy I would use is if we were challenging the AG's office for bias. First of all, I think that the Brown case deals with grand jurors and the constituency of the grand jurors. We're dealing with the constitutional authority of the prosecutor.
We're dealing with the charging document that came out of that.
Yes, apples and oranges, okay?
Who was allowed to be in the room? Who was, yeah.
Okay. But even secondarily, if we were challenging the Attorney General for bias, that might arguably be more of a effectum, or whatever the right word is. But this is one where the AG lacks constitutional authority, and that's clearly much more akin to a defectum, which the remedy would be dismissal of the indictment. John has already noted, we're dealing with, the Brown case dealt with grand jurors, we're dealing with the constitutional authority, the prosecuting authority to begin with. So I don't even think you have to get to that level, but if you did, the analogy is much more, this is a plea of defectum, not affectum, and therefore the remedy would be to dismiss respectfully.
Well, I'm leaning more toward that if someone brings something that they're not allowed to bring, they've brought a legal nullity.
Yes, I agree. I think the indictment is nullity. For that reason, we ask you, Your Honor, to grant the motion and dismiss count one.
Okay, Mid-morning break, 10 minutes.
That completes my business. Your Honor, allow me to be excused. Good to see you, Your Honor. Thank you.
We adjourn.
Noted.
So let's hear what I assume is going to be the ruling. Well, not the ruling. I think it's like a tentative ruling.
All agree that that last. I think we can all agree that that last motion was pretty dispositive of this case. If I grant it, it goes away. If I don't, we keep on trucking.
It's getting late. 10 or 12 minutes to go.
At this time, I do not find the Attorney General to have the authority to bring this RICO case. The legislature can fix that. They did with gangs. They did with domestic terrorism. I think it would be logical for them to do so with RICO, given that RICO, corrupt organizations, rarely stay in one jurisdiction. As this case, they cross jurisdictional lines. The Attorney General has constitutional duties, has statutory duties. And I think it would have been real easy to just ask the governor, let me do this. Give me a letter. The mechanisms were in place.
Yep.
And the steps just weren't followed. It's not that he couldn't have gotten that letter. There are mechanisms in place whereby he could have brought this. Now we have the question of count 2. There's no question he had the authority to bring. I think defense even concedes that in their brief. So, the remedy, and I'm going to chew on this, I'm going to adjourn for the day, because I need to figure out where I'm going with this, is the remedy, does the whole indictment die? Or just counts 1 and 3, and we proceed with an indictment that has count 2 on it, and we go from 61 defendants to, is it 5? I have no question that the state is going to appeal me. And I may be wrong. The folks across the street will tell me if I'm wrong. This is, and I welcome their opinion. If I'm wrong, we come back down and we keep on going. But that's where I'm at right now. And I don't see, I don't even get to, given the fact that I don't find he had the authority in this particular instance, not that he can't bring a RICO charge, he just didn't do it correctly in this instance. I gotta go figure out what I'm gonna write now. What would be the state's, you're gonna want, even if we go forward on count 2, you're still gonna want to appeal this. Obviously, to the extent that you need a certificate of immediate review, I obviously will write you one. I don't think redaction is, I don't know if it kills the whole indictment, because he had the authority to go in there and bring count 2. So, do we redact it? Then where are we with, do we now have 56 unindicted co-conspirators in 225 overt acts? as to,
Yeah, I think he's getting it right. I think he's talking about whether there is jurisdiction in the RICO over the defendants who are charged in count 2. Because if you have jurisdiction under count 2, presumably you have jurisdiction over, or the authority to prosecute the other counts. But I don't know if there's really no law on this as far as I can tell.
because all those overt acts are part of count 1, so they go away. Do we just go with the 5 defendants? Mr. Fowler, you clearly got something on your mind.
I do, because I had already thought about what happens if this does happen. You know, as a lawyer, you have to do that. I mean this with all due respect. We disagree with the court.
I didn't expect you to agree with me, Mr.
Right,
Fowler.
and the court knows I've known this court for a long time. We respectfully disagree. We believe that the court's analysis is wholly incorrect.
Flawed.
Wholly flawed as well. But I think that if a certificate is granted on this, which I do think a certificate has to be granted because it's not a final order.
I mean, can I throw out the whole, the entire indictment?
I don't think so.
Well, if I throw out the entire indictment,
We're talking about a certificate for immediate review, so it can go to the appeals court before the case is final.
then it is a final order. And
Correct.
then you can bring it up and they can tell me, hey, farmer, you got it wrong. You should have gone forward on count 2.
Correct. I agree. If you quash the whole thing, yes, that's a final order, no doubt about that. But if it's just count 1, I think at that point we have to have a certificate of immediate review from the court, in which case would, of course, deprive the trial court of jurisdiction, I believe, over the entire indictment. I don't think you can cleave off one, send it up, and then handle the other one. You're going to have double jeopardy issues.
Right. Well, and if I just go forward with count 2, I don't even get, I'm not going to rule on the demur issues, given that I found he didn't have the authority to bring it. Because if it's in my mind, it's a legal nullity because it never existed, so I don't have to, if they send it back down and say you got it wrong, and I've got it, then I have to look at, okay, now I've got a valid indictment.
This could take years. Imagine, so it goes up on appeal, takes months to finish, comes back down, they litigate or relitigate all the general demurs, and then he has to rule on all the general demurs. Then maybe one of those gets appealed. Now we're looking at another 3, 4, 5, 6 months. This could be years.
As far as these 2 counts are concerned, then I have to address
And this is the first trial.
the special demur issues. So I don't know that I'm not going to write anything on that because it's not right, given my ruling on the abatement. So we're done for the day, folks.
And so,
I think they all got
sua
bond.
sponte issue
Or many of them did. I don't know about all.
If I presume for a moment that the court only limits it to count 1, will the court sua sponte issue the
Certificate.
certificate? Thank you, I was watching. Or does the court need us to move for 1?
I'll grant you one. For the record, the court is going to grant a certificate of immediate review to the extent that it is necessary for the state. Yeah.
For sure, there'll be an order.
And now, I know this motion didn't concern count 3, so I'm going to go chew on that, because count 3 is arson, and it is in the same legal boat as RICO, in that there is no statutory exception allowing the Attorney General concurrent jurisdiction to bring that crime or that count. So, thank you.
Judge, are you planning to enter an order
Yeah.
today?
I'm not going to promise today.
I appreciate that there's a threshold issue of if there's no authority, can they bring count 2 in the same way with the other counts? Being one representative or defendant who's facing count 2 here in these 4 cases, I would like the opportunity to just chew on that and think about it before the court enters a ruling, because if you were to conclude before we talk again that count 2 can survive, I just think for everybody's interest, sending up the count 2 certificate, if that's what happens, whatever certificate it might be. Because we've got count 2 issues coming up that are good issues.
As Mr. Fowler pointed out, once his certificate goes up, I'm not gonna, so you want me to rule on count 2, and hey, while you're looking at how Judge Farmer got it wrong on count 1, let's look at how he got it wrong on count 2 as well?
I don't mean that, Judge. What I'd like to ask for is, could
He's challenging constitutionality of count 2.
Sure, and I guess if I may, I apologize for kind of jumping in. If this court's ruling, and I don't want, if this court's ruling is incorrect, which we don't believe it is, how can we go forward on anything else? Ms. Dixon and I can't get up and argue.
Pardon?
How can we get up and argue if we're getting a certificate of review? We're depriving the trial court of jurisdiction.
Okay, but he's saying right now, before I do that, I still have jurisdiction until I put my name on a piece of paper, correct?
I agree. Oh,
Okay.
he means right now.
So he's saying, hey, while we're all here, can we be heard on the constitutionality issue of the domestic terrorism statute?
maybe not even, Judge. There's a fork in the road coming up that's on your desk. Are we
This is such
just
a
going to
mess.
say they have no authority, and so the
I
certificate
think
goes
it's
up?
more of a T-junction, not a fork.
Sure, we are fully stopped for the moment.
Yes.
We're at a junction, Judge. But you may, and I think what I understood is, there's a chance you could consider this afternoon and decide, count 2 can survive, and we can live with it here and move forward, and maybe the state would want to do that. It sounds like they might not. My request is, could we meet back here in the morning to just be heard on what our position is for how we go forward next? We have a lot of good minds on this issue.
Well, here's, as soon as I sign, are you asking for me to like have a hearing on the constitutionality? Because once I sign the certificate of immediate review, we don't go forward. As Mr. Fowler said, now I literally lose jurisdiction until they make a decision. So then we can't keep going and talking about count 2.
Understood. If before that certificate were to issue, while you still have jurisdiction, you were to determine that they do have the authority to litigate count 2, even knowing that they're going to take the certificate as soon as they can. While the jurisdiction is here, if they have the authority to do it, theoretically, we could have litigation on count 2.
Right, yeah, I could go forward on litigation.
And I'm not suggesting that's what we should do or we should not do. I just would like a couple hours to think about it. And the reason I'm asking is,
Right, yeah, if I rule. Oh, I would rule one way or the other, it's either constitutional or not.
That'd be right. If it's just 2, it would be
You're
just
saying
the
judicial
it would just
economy,
come to.
send both issues up.
judicial economy, and for people, my client in particular, who's been sitting here for 2 years, stuck on what our position is essentially allegations of misdemeanor conduct. But now we'll sit here for that much longer while the certificate does its thing. Maybe it would be.
Hey, they may turn it around and say no. You know,
My request would just be if we can come back in the morning and at least state our position and how we think we proceed from here.
well, and does the state want to have some time to think about, hey, if we're going up, if we're going across the street, do you guys want to go across on the street on both issues, seeing as how you're going to have to get, one way or the other, they're going to be hearing about, you know, either you're going to, you know, if I rule, hey, it's constitutional, he's going to want, you're going to have to litigate it over there because these folk are going to want to appeal it. And if I find it's unconstitutional, you're going to be over there anyway. Do you want to make it, for lack of a better term, one-stop shopping? And you do not have to answer that question right away, just like Mr. Schwartz doesn't really want to answer that right away.
And I also understand Mr. Schwartz is from out of town, and I don't want to delay him in town any longer than he has to, but I would like a little bit of time to think about that. if that's okay.
Well, that's what he's saying.
Tuesday or
It's just
Wednesday.
tomorrow morning, you guys want to come back, reconvene at 9:30?
We have all week with the court.
Yes, please.
I'll see you all at 9:30 in the morning.
Such a mess. I was waiting for comments, but it's just such a mess. I'll show you count 2 real quick, just so you can see. It's called indictment. This is count 2 right here. Domestic terrorism. For these defendants, Carol, Murphy, Viola, Geyer, and Ferguson. Count 1 is the history of the universe. Yeah, pretty much. Just the history of anarchy, I suppose. Yeah. So that is it. I think there will be a hearing tomorrow, you said? So see what comes of that. It does make sense, I think, to litigate what you can and try to not consolidate, but have one kind of appellate period where the various issues are heard, but it's tricky. It sounds like he's made up his mind, but is waiting to see. He's considering hearing more issues so that the appeals can be heard at the same time. It's kind of hard to hear, but I think that's what he was getting at. So if they litigate like the domestic terrorism issue, I think there's a First Amendment challenge to that, and that goes one way or the other. Say the state wins that one, then the defendants could appeal, and you could have both appeals heard at the same time. Which makes sense. But yeah, that is what I took away from it. Yeah, it makes sense. I mean, this thing's not going to be efficient regardless. It's such a mess, but it makes sense to do it that way, I guess. But okay, man, I'm wiped out. I'm gonna call it a night. I found a copy of the motion that was granted, so I might do a separate video for that. I probably won't do it live, and just read through that at some point. This is the motion here. I'm sorry, I just got distracted by the sweatshirt. But this is the motion here, so I'll probably read through that at some point and post that. Thanks, YP. Oh, man, that was a lot. I could never be a trial lawyer. That's way too much energy. Good lord. And I was just sitting here watching it. Exactly, Kat. That's literally exactly what I was thinking. Oh, he is slime. Look at that. You should know better. Just put a little snake on that and you're good to go. Ugh. All right, guys. I'm going to call it a night, but I'll probably do something tomorrow, depending on what happens in this case. But thanks, everybody, and thanks for the memberships and all that stuff. Thanks to Kat for teaching me how to do it. And yeah, I'll see everybody tomorrow. Night, everybody. I'll see you soon. Yeah, of course. Oh, wow, that's crazy. All right, everybody. Have a good